Okay, good morning, everybody. I have 9 o'clock on my clock. Madam Court Reporter, are you all set to begin?
I am, thank you.
Okay. Good morning, everyone. We are here for a hearing in case number 23-00071 UT in the matter of the tariffs, agreements, and forms proposed by qualifying utilities for the community solar program. This is the hearing for phase 2. Today is Wednesday, January 17th, 2024. My name is Hans Muller. I will be the hearing examiner to preside over today's hearing. The co-hearing examiner today is Tatiana Perez Valero. Let's go ahead and enter appearances for the parties. I will, since we have quite a few, I will call out the party name, and if you could enter your appearance. Let's start with EPE.
Morning, Mr. Hearing Examiner, Daniel Goldberg, and next to me is Carrie Elson with Montgomery and Andrews. We're external counsel for EPE, and for internal regulatory with EPE is Nancy Burns.
Thank you, Mr. Goldberg. SPS.
Good morning, Mr. Hearing Examiner Stephanie Wool for SPS.
Good morning. PNM.
Morning, Mr. Hearing Examiner John Verhule on behalf of PNM, and with me is my co-counsel Debria Terwilliger.
Good morning to you both. City of Las Cruces.
Good morning, Mr. Hearing Examiner. I'm Anastasia Stevens on behalf of the City of Las Cruces.
Good morning. CCSA.
Good morning, Mr. Hearing Examiner. Jake Schlesinger with the law firm of Keys and Fox, and with me today is Elisa Greenwald, also with Keys and Fox.
Good morning to you both. NEE.
Good morning, Hearing Examiner and colleagues. Marielle Nanasi on behalf of New Energy Economy.
Good morning. REIA.
Good morning, Your Honor. Stephanie Zur on behalf of Renewable Energy Industries Association of New Mexico, REIA.
And NMPEC.
Morning, Mr. Hearing Examiner and Counsel. This is Jane Yee on behalf of New Mexico People's Energy Co-op.
And commission staff.
Good morning. This is David Black for Utility Division staff.
Good morning, David. Did I miss anybody?
Just Joseph Yar on behalf of local counsel to CCSA.
Okay, morning, Joseph. The recording of today's hearing, there is one official transcript of this proceeding. That is the transcript produced by our court reporter. She will supply that transcript to the commission. It will be maintained on eDocket. It is the only official transcript. No party is authorized to record this proceeding. The exhibits, our court reporter will also collect exhibits from the parties and transmit them to the commission as the official record of exhibits admitted during this hearing. I gave you directions about exchanging exhibits utilizing Dropbox. From what I see this morning, it looks like all the parties were able to access that. Do we have any issues with documents loading by any of the parties? Did anyone hit any issues that I need to address, or is everything accounted for?
Mr. Hearing Examiner, one of our witnesses noticed some corrections after we uploaded to Dropbox, and there's just two small little corrections to the testimony, and we just wanted to be, see if we can re-upload as a corrected exhibit, either now or when we introduce the witnesses, one of the later witnesses.
Okay, why don't we go ahead and do that when we introduce, if it's just minor corrections.
Okay, thank you.
And I want to note, as we talked about during the pre-hearing, there's a folder that contains administrative notice documents. I have put those in a separate folder, and I have, for purposes of clarity, I have labeled those with numbering. They are now in that folder referred to with AN1 through AN15, I believe. I did that just for purposes that we all are referring to the same document when those are referred to. As I mentioned at the pre-hearing, we are doing that for purposes of clarity. So we all are referring to the same document for purposes of this Zoom hearing. So I am taking administrative notice that that is the document we are referring to the extent that there is a legal argument within those documents. I'm not taking notice of that, of course, but that is what we should be referring to if you are referring to a document, just so we all are seeing the same document. And please note the numbering that I gave them, so we're not scrambling around for when you are referring to a document. Were there any?
Examiner? This is
Yes, Anastasia.
I have one procedural question and one practical question about that. First of all, the practical question, when I downloaded them yesterday afternoon, they didn't have numbers. So should we just kind of go in and start over again on the Dropbox on the administrative notice documents?
I renamed them this morning.
Yeah.
So they probably have a number now.
Oh, well, I'm chicken. I'm always afraid I'll be disconnected, so I download everything and take it out of my desktop. And the other question in that regard is this is the substantive one, is by putting them in that box and numbering them, have you accepted them have you taken administrative notice? Is that the intent of last week's pre-hearing conference, or do we have to discuss them one by one as they're actually used?
To the extent that by saying I am taking administrative notice that is the document we're referring to, I am, admitting them onto the record as of right now. Okay. To the extent that there is any legal question, regarding that copy, that'll be handled during the individual once we refer to them with a witness. But I reviewed them; they look proper. So to the extent that we are going to be referring to that is what I'm taking administrative notice now for the record.
So we don't have to go through the rigmarole.
We don't have to go through the rigmarole. Correct.
Thank you so much.
Ms. Yee, you have your hand raised.
Yes, Mr. Hearing Examiner Mueller, I wanted to notify or let you know, and the parties know, that I uploaded exhibits yesterday, specifically NMPEC exhibits 3 through 8 that have inadvertently watermark on them that say confidential. And I checked with Mr. Verheul, and he confirmed that PNM, those, by the way, were responses to discovery requests from NMPEC. And and I did list those exhibits on my exhibit list. And because I have tired eyes, I hope that's all that's failing me. I did not see that watermark. It was a little bit faint. And so I checked with until yesterday. And so then I checked with Mr. Verheul, and he confirmed that those documents do not contain any confidential materials. So I would like to alert you and counsel that was inadvertent, so nobody freaks out the way I did yesterday afternoon when I saw that. And I wanted to ask Mr. Hearing Examiner, would it be necessary for me to swap those out with clean copies, or would this clarification suffice for the record?
To me, that explanation suffices. I don't think the watermark will have any bearing. Mr. Verheul, excuse me, can you please confirm what Ms. Yee said for the record, to the extent
yes,
that those do not contain confidential information?
Yes, Mr. Hearing Examiner, Ms. Yee's explanation was 100% accurate as far as PNM can tell. We appreciate her attention to protecting confidential material had there been any.
That being said, that the PDFs that contain the watermark are sufficient. I do not request a cleaner copy at this time for purposes of that.
Thank you, Mr. Hearing Examiner.
There are a couple of documents that I want to address that were loaded into Dropbox by SPS. SPS has 3 documents that appeared in Dropbox in Excel format. For purposes of the record, I would ask you to please reload those in PDF format, as I don't want there to be any documents that can be edited or contaminated on the record. So for purposes of today, those exhibits as they are can stand, but I'll basically give you 24 hours to upload a copy of those in PDF format. Like I said, just so they cannot be edited or risk contamination. Yes, John, you have your hand raised.
I do. Thank you, Mr. Hearing Examiner. I'm going to ask you at this point if we can excuse PNM witness Cindy Buck, and I'll explain why. I had asked previously, but CCSA was the only party that had any cross-examination scheduled for Ms. Buck. Yesterday, in conversation with counsel for CCSA, they conceded that they did not need Ms. Buck's attendance at hearing in exchange for certain other documents that we would stipulate to admission of, which we agreed to. So to the best of my knowledge, there is no cross-examination for Ms. Buck. She's traveling out of state at the moment. She was going to have availability issues anyway. If we could just excuse her entirely, that would simplify things for everyone.
Okay, let me just get confirmation. Jacob, I see you have your hand raised. I'll get to you in a second. Let me just confirmation from CCSA that you are waiving cross-examination for PNM witness Buck.
Yes, Mr. Hearing Examiner, as Mr. Verhule mentioned, we've agreed to waive in lieu of the admission of two discovery responses that we received from PNM. So if we can get those admitted, we could just do that right now even, then we could certainly waive Ms. Buck.
That is fine. I'm going to waive PNM's witness, Ms. Buck. Her attendance for this purposes of this hearing is no longer required, as cross-examination has been waived by the party. To the extent is that loaded into Dropbox right now, Mr. Schlesinger?
Yes, it is.
Okay. To the extent that that those exhibits will be received then as part of that waiver. So that is which number are you looking to admit?
Sorry, that would be what has been marked as CCSA Exhibit 12 and CCSA Exhibit 13.
Okay.
And that's discovery response from PNM to CCSA 7-15 and 7-20.
Okay. PNM, any objection to those being received onto the record?
No objections.
All right. CCA Exhibit 12 and CCSA Exhibit 13 are admitted onto the record.
Thank you, Mr. Hearing Examiner. I also heard you direct SPS about certain Excel dockets or documents. I'm not sure about theirs, but I know that we did upload 2 documents, I believe, that are, well, actually 3, but only 2 one was probably inadvertent. But we uploaded CCSA Exhibit 6 and CCSA Exhibit 7, which are both very large spreadsheets. That's EIA data that I intend to talk to EPE's witness, Mr. Shishel, I hope I'm pronouncing that correctly, about. Those are impeachment exhibits that may or may not need to be admitted, but they are literally thousands and thousands of lines of data that were pulled from the EIA website, the Energy Information Administration website. We can convert them to a PDF, but it will be a mess and really hard to look at. Given that those data sheets do exist on this government agency website, I'm not concerned about tampering because we can always go back to the EIA website to verify their accuracy. But if you prefer that we PDF them, again, I'm happy to do that. I'm just worried that because of the size of them, they'll be really difficult to read.
Mr. Hearing Examiner, this is Marielle Nanasi, New Energy Economy. If I could offer something that we've done like in the last PNM rate case, what we did was we had the actual exhibit, so CCSA Exhibit 6 as 6A, so that all parties could see the fulsome document, but to the extent that only a portion of it was actually going to be questioned about, so 1 page or 2 pages of that entire thing, then that was CCSA Exhibit 6, and then CCSA Exhibit 6A was the full Excel sheet so that people could reference it, but that wouldn't be part of the record, just the 6 would be. So I just offer that as an alternative because it's worked in the past.
And that just saved me a little bit of talking, so I appreciate that. To the extent that I'm assuming of the large spreadsheet, you are mainly going to be referring to probably a page or two during cross-examination. To the extent that you can PDF the specific page or pages that you'll be referring to as the exhibit, I mean, that'll save some time rather than scrolling through the exhibit as well. If we can get the individual pages that you'll be referring to, that way you won't have to PDF the entire, and that can be cut and pasted from the Excel sheet. I think that'll save a little bit of time and for the record. So are you amenable to that?
I believe yes. I think we'll have to see how the cross exam goes to see if we actually even need these. But and it's going to take me a little bit of time to figure out which are the pages that we would want to PDF. But if it's okay, I'd like to refer to the spreadsheets for this morning, and then I can do the PDF and clean it up on the record tomorrow.
Okay, that's acceptable. Thank you.
Okay, thank you.
Stephanie, you have your hand raised?
Yes, thank you. I have 2 matters for you to raise. The first is I'd like to also enter an appearance for Dana Hardy and Tim Rode. They're supporting my Pro Hac Vice admittance in this docket. And the second is a scheduling concern we have now with SPS witness Ms. Clem. She has a scheduling constraint and she's scheduled to go third last on Thursday during the PM session. And SPS would propose that Ms. Clem go after Ms. Lee. So she would go in the second witness spot on Thursday PM.
Okay, I have no problem swapping that out.
Thank you.
All right. Looks like all the parties have appeared. There are no parties that have failed to appear today. The schedule and breaks today, we'll go for an hour and a half and then take a 10-minute break. Lunch is from noon to 1 today, and we will wrap up at 5 p.m. Oh, Jacob, you have another question?
Sorry, just wanted to let you know that I do expect that our cross-examinations will be overall, maybe not for each witness, but overall less than what we've put in. So I just wanted to alert you that as we've gone through and prepared more, we've been able to hone those a bit. So I don't expect that we'll need all of the time that we requested. Just wanted to let you know.
I appreciate you giving me that heads up because definitely tomorrow we'll be running on a tight schedule. Today we'll wrap up at 5. To the extent this in any way interferes with completion of examination, we will have another day of hearing. This is principally for our court reporter so that she has time to rest during the day. Madam Court Reporter, obviously you can interject at any time and direct people to slow down or adjust their audio so you can hear appropriately for the record. Mario, give me one second. I see you have your hand raised. Order of witnesses today was indicated in my second pre-hearing order. For today's session, we are beginning with EPE's witnesses, continuing through to the afternoon. At the conclusion of the EPE's witnesses, we will have Mr. Babe from PNM. Are there any, for those witnesses who were scheduled to give testimony today, do we have any conflicts or anything else that has come up that would require rescheduling them? Hearing none, we'll stick to that schedule, and I do have the requested cross-examination times. And Mario, your question.
Thank you, Mr. Hearing Examiner. I wanted to see if I could switch the times exactly for Mr. Schichtel and Mr. Babe. So I had 25 minutes for Mr. Schichtel and 45 minutes for Mr. Babe, and I'd like to switch those, please.
Note that. Okay, I have changed those accordingly.
Thank you.
Hearing examiner questioning today. The commission's order in this matter vested the hearing examiners with authority to conduct any necessary hearings and to take any other actions consistent with commission procedure. Under section 62-6-4 and MSA, the commission, and by extension through the delegation of powers, the hearing examiners also exercise broad power to supervise and regulate utilities in order to protect utility ratepayers and ensure the utility provides reasonable and proper service at a fair, just, and reasonable rates. To the extent that the hearing examiner asks additional inquiries during this proceeding is consistent with the delegation of that authority and practice of the commission. So the scope of redirect then would be matters arising from examination by the hearing examiner or commissioner. Recross would be limited to matters arising from redirect. And the basic import of these rules is to ensure orderly questioning today. Public comment, my office has indicated that we had no requests for public comment today from any individuals. Therefore, the public comment section of this hearing is closed. I had a couple of motions in reviewing the docket that were outstanding but uncontested that I just want to address for purposes of the record. First, there was an unopposed motion by NEE to intervene out of time, and EPE had a motion for leave to file direct testimony of Mr. Schichtel out of time. There were no objections to those motions, so for purposes of the record, both motions are granted clearly. I just didn't want to leave those hanging. So for purposes of the record, I am granting both of those motions. Not that, and like I said, there were no objections, so there shouldn't be an issue with that. I just wanted to put that on the record officially. Is there anything else before we begin receiving evidence today?
Yes.
Ms. Sarah.
You had in your procedural order that parties would be allowed to exit the hearing at times subject to the rule that any decisions made in their absence, they're bound by. And I just wanted to let you know, I expect to be leaving the hearing to take care of other business on a few occasions, but I'll be listening to YouTube, and I accept the order that it would be subject to any rulings made in my absence.
Thank you for the notification. Anything else? All right, let's begin. EPE, go ahead and call your first witness, please.
Thank you, hearing examiner. EPE calls James Schiestel.
Mr. Schiestel, would you raise your right hand for me, sir? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Good morning, Mr. Schiestel. Will you
Morning.
please state your full name and spell it for the record?
Certainly. My name is James Schiestel, and the last name is spelled Schichtl.
And what is your current profession?
I am employed by El Paso Electric Company as Vice President of Regulatory Operations and Resource Strategy.
Do you have before you a document that was previously marked as EPE Exhibit 1?
Yes, I do.
Do you know what that document is?
Yes, it is my direct testimony in phase 2 of this proceeding filed on September 18th, 2023.
And was your direct testimony drafted by you or under your supervision?
Yes, it was.
Do you have any changes to your direct testimony?
No, I do not.
Is your direct testimony true and accurate to the best of your knowledge and belief?
Yes.
If the questions in your direct testimony were asked today, would you give the same answers under oath?
Yes, I would. I would note that my title has changed since my production of this testimony. I was previously Vice President of Regulatory and Governmental Affairs. My title is now Vice President of Regulatory Operations and Resource Strategy, but all of the my responsibilities with respect to that are relevant to this proceeding remain the same.
Thank you for that. Mr. Hearing Examiner, we'd like to offer for admission at this time EPE Exhibit number 1 with all associated exhibits.
Okay. Move us to enter exhibit EPE Exhibit number 1 and all according exhibits onto the record. Any objection? Hearing none, they are admitted.
Mr. Schiestel, do you have before you a document that was previously marked as EPE Exhibit 2?
Yes, I do.
Do you recognize that document?
Yes, it is my rebuttal testimony in phase 2 of the community solar proceeding filed on December 8th, 2023.
Was your rebuttal testimony drafted by you or under your supervision?
Yes, it was.
Do you have any changes to your rebuttal testimony?
No, I do not.
Is your rebuttal testimony true and accurate to the best of your information and belief?
Yes.
If the questions in your rebuttal testimony were asked today, would you give the same answers under oath?
Yes.
Mr. Hearing Examiner, would like to offer EPE Exhibit number 2 and all associated exhibits.
Request is for EPE Exhibit number 2 and accompanying exhibits to be admitted onto the record. Any objection? Hearing none, they are admitted.
Thank you, Mr. Hearing Examiner. EPE tenders Mr. Schiestel for cross-examination.
Okay. And for cross-examination, I have CCSA. You may begin.
Thank you, Mr. Hearing Examiner. Can I request, maybe this is unusual for New Mexico, but can I request that only Mr. Shishel have his video and his counsel just to make it easier to see, or do you prefer to have everybody on the screen?
To the extent that are you asking to basically have a larger view of Mr. Shishel, or?
Yeah, I can do that. You're right.
You can change your view to speaking mode.
Got it. Thank you.
To that'll help you out for that.
Thank you. Okay, thank you. Good morning, Mr. Shishel. Did I pronounce your name correctly?
Perfect. Thank you.
Excellent. As a fellow SCH name bearer, I sympathize with the mispronunciations. Good morning. My name is Jake Schlesinger. I'm representing CCSA today. It's nice to meet you.
Good morning.
Good morning. I would like to begin this morning by discussing subsidies and the statutory required limits on those subsidies. So you are aware, I'm sure, that New Mexico law requires the commission to adopt rules to establish community solar, and provides that if the commission determines that it is in the public interest for non-subscribers to subsidize subscribers, that non-subscribers shall not be charged more than 3% of the non-subscribers' aggregate retail rate on an annual basis. Correct? Familiar?
That's my understanding, yes.
Okay, great. And you would agree with me, I think, that the Act, the Community Solar Act, nor the Commission's rules define the term subsidy, correct?
I believe so. I don't think it's a defined term in the CSA. Right.
Okay, and so it will be important for the commission in this proceeding to clearly define what constitutes a subsidy, correct?
I think that would be a good start, yes.
Okay. And it's also correct, is it not, that EPE proposes to calculate the subsidy by summing the total cost of the bill credits and reducing those by what EPE considers to be avoidable costs.
I mean, if you're referring to the subsidy amount allowed under the CSA, EPE defines that limit as a percentage of the aggregate retail rate, some definition of aggregate retail rate for the classes participating. I would say it's the classes participating in community solar. So that limitation establishes a level of additional contribution towards subscribers by non-subscribers up to some limit. What we have said is that there is an avoided cost portion of the bill credit, and then there is a cost a cost reflected in the bill credit, costs that are unavoidable by EPE, meaning those costs are not reduced when subscribers join community solar and receive energy from community solar facilities. It's that portion of the total bill credit that is limited in the sense of how much non-subscribers would contribute.
Oh, okay. And I think you answered my question, but I mean, just trying to get us on the same page here for the purposes of questioning. So it is correct, though, that EPE proposes to reduce the cost of community solar by avoidable costs, which you define as fuel, purchase power, and avoided variable O&M, correct?
Well, I'm only differing with your characterization of it as reducing the cost. What we're noting is that when subscribers receive energy from a community solar facility, they are replacing energy that would otherwise be supplied by the utility. And that energy has a cost associated with it. Let's take fuel, for example. That if the utility is no longer providing it, we're no longer incurring that cost. And so it's avoided in that sense. I don't know about describing that as reducing the cost of community solar, but it basically says that the utility is no longer incurring that cost associated with that energy, so it doesn't have to be recovered.
Okay. So the benefit of, excuse me, let me finish my question, please.
Sure.
The benefit of community solar, according to EPE, is the avoided fuel and the avoided variable O&M, to state it another way, correct?
Well, I don't think we've characterized that as a benefit of community solar, but it's certainly a reasonable credit against the community solar subscribers bill. I think it's important to note that, or to start this with, when we bill a community solar customer, we first bill them at all the applicable rates for their total metered consumption.
Your Honor, I'm going to ask to direct the witness to answer the question, or I'm not going to actually save any time today. We'll get into all of these issues, but I'm going to try to do it methodically. So if you could limit your response to simply the question that was asked, I'd appreciate it.
Let's clarify that. Mr. Schlesinger, can repeat the question, and I'll direct the witness to answer directly.
Okay, thank you. EPE agrees that fuel purchase power and variable O&M are avoidable costs from community solar. Correct?
Yes.
Thank you. Okay. And I actually do think you answered my next couple of questions, so I'm going to skip ahead here. Okay, and in contrast, CCSA has taken the position that the methodology for determining avoidable costs should use a longer-term time horizon, which in turn would enable consideration of avoided or deferred capacity investments. You understand that to be our position?
Yes.
Okay. And so the main difference here between EPE's position and CCSA's position is basically how long of a time horizon the Commission should consider when determining what costs are avoided by community solar. Is that fair?
Well, there certainly is a difference between the time horizons, but I'd say that's not the only difference.
Okay, fair enough. But you state in your rebuttal testimony that using a longer-term time horizon is fairly standard in value of solar analysis. Do you recall that?
Yes.
Okay. And would you agree with me that there are a number of states, jurisdictions out there that utilize such an analysis to quantify the avoidable costs of community solar?
There are certainly a number of states and jurisdictions that use value of solar. They don't all incorporate the deferred or avoided future capacity cost components of the value of solar, of the total value of solar number.
Okay, but you agree that some of them do, right?
Yes.
Okay, and presumably that's because those states or jurisdictions found that analysis to be reasonable, yes?
Apparently, I would just note that those are generally associated with behind the meter solar generation. In other words, rooftop DG or other distributed generation resources. I don't know that I've seen value of solar analysis specific to what we're talking about here in terms of a community solar facility.
Okay, we can address that in briefing. But would you agree with me, just hypothetically, if we knew for sure that community solar would result in future avoided capacity investments, would you agree that that would be a benefit?
Under that hypothetical, that you had that certainty, I could see characterizing that as a benefit. I don't necessarily see that it's clear that who should pay for that benefit.
Okay, fair enough. And that benefit, hypothetically, if it were to materialize, that would be a benefit to future customers, correct?
Well, it would be, yes, future customers, including the current customers in the future. Yes.
To the extent they're still around, yes. Okay. It's correct, however, that EPE's methodology, if there were such a future benefit, that benefit would not be reflected in the calculation of the subsidy, correct?
That's correct.
So under that hypothetical, where it's no certain, that would result in today's community solar subscribers subsidizing future subscribers, wouldn't it?
No, I wouldn't agree with that.
You wouldn't. Okay. Okay, fair enough. All right. On this, finally, on this point, on this line, you stated in your testimony, and I can refer you if you want, it was page 38, line 6. You stated that EPE does not agree with future avoided or deferred capacity cost component in CCSA's methodology. And then you go on to state that the total bill credit costs consist of 3 components. And the first one that you list is actual avoided costs as defined by EPE. You see that?
Yes.
Okay. Isn't it ultimately up to this commission to decide how to define avoided costs?
I would say yes, as it relates to cost responsibility for the program spread across subscribers and non-subscribers. Yes.
Okay. So EPE is a regulated utility and it is subject to this commission's determinations and jurisdiction, correct?
Yes.
Okay. All right. Thank you. Moving on. Once the definition of the subsidy has been decided, it's also important to figure out how to calculate the 3% impact to non-subscribers, correct?
The 3% limitation on subsidy, yes.
Okay. And so that's another issue that the commission needs to decide in this case, right? How to calculate that 3% limitation?
Yes, as I understand the CSA, the first determination is that there's a public interest justifying a subsidy by non-subscribers. Obviously the second would be, or a subsequent one would be the determination of how much of a subsidy at max that could be supplied. So that would be the 3%. Okay,
that's a helpful clarification. Thank you. And with regard to calculating that 3% impact to non-subscribers, you state in your testimony, beginning at the bottom of page 26, that the only area requiring any interpretation of how to do that calculation would be the definition of non-subscribers for purposes of the aggregate retail rate. Correct?
Yes.
Okay, and we'll talk about the definition of aggregate retail rate in a little bit, but right now I want to focus on non-subscribers. And you agree, and I think CCSA agrees as well, that non-subscribers should include all retail customers, not just those classes which contain community solar subscribers. Correct?
Well, I think that's a determination for the commission to make. I noted there, that you could interpret this to be class specific on the calculation of the aggregate retail rate. But in terms of who pays as non-subscribers, I do think there's a consideration there that if you can't participate in community solar, you shouldn't be required to subsidize community solar. Again, that's I think that's a determination that needs to be made by the commission, when we look at non-subscribers paying.
Sure, obviously the commission will need to decide this, but my question is your position, and I can refer you to your rebuttal testimony at the top of page 27. And you state, starting at line 2, for example, should the subsidy cap be determined on a rate class basis, meaning that residential non-subscribers would only subsidize residential subscribers, or should the cap be calculated on a total retail basis as I presented in Q21? So your position, the way that you presented it, was on a total retail basis. That is your position, correct?
For the calculation of the total subsidy limit, yes.
Okay.
And I'm making a
I'm sorry, I'm going to move on to the next question, if that's okay. Are you aware that some of the other...
Mr. Hearing Examiner, Mr. Schiestel needs to be able to finish his answers. If CCSA counsel, wants him to answer directly, Mr. Schiestel should be able to have the opportunity to finish answering.
Okay, to the extent that he had answered whether that was his position and testimony, I feel he answered it. So I feel that question was answered. I understand that we are clarifying a few things as we go, that will be afforded to Mr. Schiestel on any redirect. But to the extent that I feel he answered Mr. Schlesinger's question, I believe he did answer it. It was a simple, straightforward, that's your position question. So let's continue with questioning.
Thank you, Mr. Hearing Examiner. Mr. Schiestel, are you aware that some of the other utilities in this proceeding have taken a different position on this issue?
I don't recollect the other positions on this particular issue, but it wouldn't surprise me.
Okay, so would it be fair to say that EPE did not coordinate with the other utilities in determining what would be a reasonable interpretation of how to define non-subscribers?
Not that I recollect.
Okay. Okay, and I'd like to look at your calculations that you provided in a response to discovery to calculate the 3% limit. And this is contained in what's been marked as CCSA Exhibit 5. And I can share my screen if that's helpful, Mr. Hearing Examiner.
Let me make you co-host to have that ability.
Excellent, thank you. Okay, does everybody see CCSA Exhibit 5 here on the screen?
Yes.
Yes.
Okay, great. Mr. Schiestel, you were this is a interrogatory number 7-3 from CCSA to EPE, and you were the sponsor of this response, correct?
Yes.
Okay. And does this look like the response that you provided and the attachment that you provided here on the next page?
Yes.
Okay, great. So at this point, I'd like to move for the admission of CCSA Exhibit 5.
Request is for CCA Exhibit 5 to be admitted onto the record. Any objection? Hearing none, it is admitted.
Okay, great. In this chart here, this table, Mr. Schiestel, you calculate the upper limit on the 3% subsidy cap for EPE, and you calculated that to be $3,605,431, correct?
On a total system basis, I mean, on a New Mexico basis, yes.
Right, for the EPE jurisdictional utility.
Yes.
Okay. Are you aware that Mr. Barnes calculated that 3% subsidy cap for EPE to be for about $4.3 million? Do you recall seeing that?
I do not.
Okay, I can just pull that up to refresh your recollection here. Here it is, about 4.3 million.
Okay.
Okay.
It doesn't, I'm sorry, the period or that I don't see the period over which this calculation is that on the prior page?
I don't know if it's on here. My understanding in talking to Mr. Barnes is that he matched the same time period, which was year ending September 2023. So that's the time period you used.
Okay, I just note that I hadn't seen the period defined for this, but okay.
Okay, we can clarify with Mr. Barnes when he takes the stand. Okay, so going back to your, you guys have a pretty different number here, 3.6 versus 4.3 million. Do you know why you guys got different numbers, considering that you're both using all customer classes?
No, that's why I asked if we were consistent on the period, especially given the large differences in fuel costs, say between 2022 and 23. Could be one explanation, but it could be the period.
Okay. And let me ask you, where did you get this $120 million figure for the total billed revenue? What was the source of that figure?
We have an internal report on our on revenues and sales that I utilize.
Okay, but this is the total billed revenue for all rate classes during the year ending September 2023 period?
Yes, that's what I indicate.
Okay. Are you aware that EPE is required to report all of its sales to the Energy Information Administration, or the EIA?
I'm not familiar with the requirement, but that wouldn't surprise me.
Well, are you familiar that EPE does report total sales to EIA?
Not directly familiar, no.
Do you know that EIA tracks utility sales data?
I use EIA a lot, yes.
Okay, so you are familiar with EIA. Are you familiar with Form EIA 861M?
No. Not by numerical reference, no.
Not by name. Let me show you one here. This is the 2023 Form EIA 861M. It's a huge spreadsheet. Is this something that you've looked at before?
No, I haven't referenced this one then by my recollection, but I'm certainly familiar with the data they compile.
Okay, and would you agree with me that this includes the EIA sales data for all of its rate classes, this particular form being for 2023?
Again, objection. Mr. Schieftel just said he's not familiar with this form.
I think to the extent that he's not familiar with this individual form has been noted for the record. Mr. Schlesinger, could you rephrase your question, please?
Do you believe that this form accurately represents EPE's 2023 sales data?
Again, I'm not familiar with the form. I have no reason to think otherwise. I'm just not familiar with how the data is provided by EPE to EIA, on what basis, how frequently, what is included in the total sales. I'm just not that familiar with this form and the data that's supplied.
Okay. Well, I guess, Mr. Hearing Examiner, I would move for administrative notice of CCSA Exhibit 6 and 7, which come from a U.S. government agency's website and purport to include EPE's sales data. I understand Mr. Schiestel says he's not familiar with this one in particular, but I think it is within the commission's authority to take administrative notice of government records.
Okay.
Objection. There was no foundation for this form. This wasn't in the pre-hearing memo. Mr. Schiestel just said he has no knowledge of it. For the commission to take judicial or administrative notice of it when, you know, the parties aren't even familiar with it, be inappropriate.
May I respond?
Yes. Response.
Thank you. And Mr. Goldberg is correct that we did not include this in our pre-hearing memo. This is intended to be an exhibit to impeach the witness, and so I don't believe it was required. But generally speaking, I believe that we found an error in Mr. Schiestel's math in his calculation of the total retail sales, and this is reliable data that the U.S. government has that we can check against. And so I would propose to put this into the record. I don't need to ask Mr. Schiestel any additional questions about it, but it would give parties and the commission an opportunity to verify his math.
Mr. Hearing Examiner, can I respond to that?
Let me, I think I'm going to kind of rule right now. To the extent, I'm not going to take administrative notice. I mean, this is one of our documents that we talked about before, that I'm not going to take administrative notice of the entire document. To the extent that Mr. Schlesinger, is this something that your witness referred to? Or will be referring to? Let me ask that.
It is something he can certainly refer to during his testimony in this proceeding, yes, but it is not something that I believe he referenced it in preparing his testimony, but I don't believe he included it in his actual testimony.
Okay, here's what I'm going to do. I'm not going to take administrative notice of it right now. To the extent that the witness has said he's not familiar with the form, I don't feel it's appropriate to take notice of it right now. What I'd prefer you to do is, like I indicated earlier, is to basically reduce that down to what you want me to take notice, the numbers that you want me to take notice of. Put that in a PDF, and we can refer to that with your witness, if that is something he relied on, and I'll make a determination whether to take administrative notice of that at that time.
Understood. Thank you.
If I may, Your Honor, I apologize for interrupting. This is Joseph Yar on behalf of CCA. I do want to clarify the record for one point. The witness, Mr. Schiestel, did acknowledge a complete familiarity with EIA documents. So I think there's a kind of a misunderstanding in the discussion here that the witness isn't familiar with EIA documents, and that's what's kind of, I think, is misunderstanding here. Maybe not this form, but it's not clear to me that he's not familiar with looking at EIA and referencing EIA.
Okay, Mr. Yar, you're making briefing points right now. To the extent that has not been put on the record, I understand your point. And I'll take that under consideration. However, I don't have that on the record right now. To the extent that you want to make that argument in briefing,
well,
I would certainly entertain that. But I have made the determination I'm not going to take administrative notice right now.
Understood.
That is not to say I'm not going to take administrative notice of it during the course of this hearing, but not at this present time.
Understood, Your Honor. I was just making a clarification point. Thank you, Your Honor.
Thank you.
Mr. Hearing Examiner?
Mr.
I'm
Verhul.
sorry. Yes, thank you. I'm sorry to interrupt. Normally in practice before the PRC, I'm not accustomed to seeing multiple attorneys from a single party argue objections, cross-examine a witness, do those sorts of things. Normally it's one attorney per witness. Can you clarify whether or not that's a practice that you intend to uphold in this hearing today?
Yes, and thank you. I was about to make that point as well, that we have already identified the attorneys responsible for cross-examination, which is another reason why I wanted to indicate, there's briefing points and and who we've assigned for cross-examination. So for purposes of that moving forward, let's stick to that. I understand to the extent that one attorney wants to talk to the other attorney, please call for a break. But by interjecting yourself, we're eating up time is all we're doing.
Understood, Your Honor. Thank you.
Yep. So if we could proceed with cross-examination at this time, like I said, I'm not taking administrative notice of that document currently.
Thank you, Mr. Hearing Examiner. Okay, I'd like to move on. So you, as we just talked about, you stated in your rebuttal testimony that the only area requiring any interpretation on calculating the 3% impact to non-subscribers is the definition of non-subscribers for purposes of the aggregate retail rate. You recall that?
Yes.
Okay, but it is also true, isn't it, that CCSA and EPE interpret the term aggregate retail rate differently, isn't it?
Yes, I believe CCSA uses the TARR as defined in the CSA.
Correct. And so it will be important for the commission to make a determination on what the proper interpretation of aggregate retail rate is, correct?
Certainly for setting the level of subsidy, that's the first thing that needs to be determined on whether it's defined on a class basis or a total system basis. But yes.
Okay, whether it's defined on a class basis or a total system basis is what we just talked about. But in addition to that, it's also important to know what is an aggregate retail rate separate from that, correct?
Yes.
Okay. And you pointed out, I believe already, that CCSA interprets it to mean total aggregate retail rate as defined in the statute. And then in contrast, you defined it as the total amount of a qualifying utility's demand, energy, and other charges converted into a kilowatt hour rate, but does not include, sorry, I lost my place here. You defined it as the total annual billed revenue for all rates and charges divided by total energy sales for the same year, correct?
Objection. He's asking a compound question. Are you asking how CCSA is defining it or how EP is defining it?
Could you clarify your question, please?
Yeah, let me just break it up into two, sorry. He had already said what CCSA did, so that's why I did that. But CCSA interprets aggregate retail rate to be synonymous with total aggregate retail rate, correct?
That's my understanding, yes.
Okay, and the statute and the rules define total aggregate retail rate as the total amount of the utility's demand, energy, and other charges that are converted into a kilowatt hour rate, but does not include charges described on a qualifying utility's rate schedule as minimum monthly charges. That's what total aggregate retail rate is, right? And I can pull it up if you need me to.
That's
Objection. Is counsel reading the statute or interpreting the statute?
I'm reading
Wait.
a section of the statute. Or I'm sorry, a section of the rule. Let me put it on the screen.
Can you please point us to the section of the rule that you're reading from?
Okay. Can everyone see the rules on their screen?
We can.
Okay. So, Mr. Schiestel, my question for you is total aggregate retail rate, which is the definition of aggregate retail rate that CCSA is using. That is defined here in Part B of the statute. And this is the part that I'm looking at. It's the total amount of the qualifying utilities demand, energy, and other charges converted into a kilowatt hour rate. And then skipping ahead a little bit, but does not include charges described on a qualifying utilities rate schedule as minimum monthly charges. Correct?
Yes, but there are other exclusions, but yes, that section reads that way.
Okay, fair enough. And then in contrast, EPE defines aggregate retail rate to mean the total amount of billed revenue for all rates and charges divided by the total energy sales over the same time period, correct?
That's correct. That is my interpretation of that aggregate retail rate. And I think what differentiates that from the TAR is that the TAR is a defined term under the statute. And so I don't think it's appropriate to say they're the same thing.
Okay, fair enough. But your calculation of aggregate retail rate, you include minimum monthly charges in that, right?
It is essentially all billed revenue for the period. So everything that retail revenue, everything that's billed to customers is reflected in that number. And that's the purpose of one benefit of that interpretation, I think, is that it's simple. It's just total revenue divided by total sales.
Okay, and so the answer to my question is yes, right? That you include minimum monthly charges in total revenue, right?
To the extent that they are billed to customers as revenue, yes.
And they are billed to customers as revenue, right?
If they exist, yes.
If they exist, which they do for most rate classes, correct?
Well, I think that's where, again, you then end up having to interpret the different kinds of charges on a tariff. But we calculate the TARR in Mr. Carrasco.
I'm sorry, Mr. Schiestel, this is beyond the scope of my question. I'm just trying to clarify that when you calculate total revenues, you are including any minimum monthly charges that are charged to customers, correct?
I am including all charges that are charged to customers, yes.
Okay.
Objection. Okay, never mind. He's already finished the question. I'm sorry.
Okay, and in contrast, Mr. Barnes excludes those minimum monthly charges by using the TAR, correct?
If Mr. Barnes is following the definition of TAR, yes.
Okay. And so, assuming that Mr. Barnes and you are looking at the same data and using the same numbers, if Mr. Barnes removes the minimum charges from the retail revenues and you include them, Mr. Barnes theoretically has a lower number than you, correct? All else being equal.
Yes, if we were using the same data, yes.
Okay, and so if you were to take 3% of Mr. Barnes's theoretical number, it would result in a lower subsidy amount, a lower subsidy cap than what you would theoretically calculate by including the minimum charges, right?
Objection. This is beyond speculative at this point. He's having Mr. Schiestel calculate a theoretical number based on a theoretical number.
Do we have a specific reference point, the numbers you were referring to? I'm getting a little crisscross myself.
Sorry, I'd like to rephrase, but I'm not asking about numbers. I'm asking about methodology here. And so I don't have any specific numbers to refer to because I'm just asking about the method of how to do this. So I can try to rephrase.
Okay, please rephrase, and I'm also going to pitch in that we're at you have 5 minutes remaining for your cross exam too.
Okay. By removing the minimum charges, I think you already agreed that Mr. Barnes would have a lower calculation of aggregate retail rate, assuming the data was the same. And so 3% of a lower number results in a lower number, right?
Well, I didn't agree that he would have a lower aggregate retail rate. I agreed he'd have a lower revenue number. So the aggregate retail rate is the revenue divided by kilowatt hour sales. So the question would be, are our kilowatt hour sales numbers different as well as a result of the difference between, say, the full aggregate retail rate and the TAR? Because the 3% is applied to the rate, not the revenue.
Okay. But Mr. Barnes' methodology of using the TAR, all else being equal, would result, again, assuming you're looking at the same data, in a lower cap than what your method would produce.
Not
right?
not necessarily.
Okay, fair enough. Let's move on. I want to talk about what happens after the 3% cap is exceeded. You take the position that the subsidy cost over the cap should be recovered from all subscribers, correct? And you can
Yes, to the extent that there are costs above the cap. I believe the CSA would require, I guess by process of elimination, that the only parties to contribute to those would be subscribers.
Okay, I'm just asking about your position and you're eating up my time. So your position is that it should be charged to all subscribers in the community solar program. Yes or
Yeah.
no? Yes, thank you. And so under your proposal, early subscribers to the program may be charged for costs associated with exceeding the 3% cap sometime in the future, right?
To the extent the credit given to customers exceeds the cap, yes.
Okay. And when those customers, the early customers, sign up for the program, they would not know whether or not they will eventually be charged for costs that exceed the 3%. They wouldn't know that at the time they signed up, right?
Well, that depends on how cost recovery is approved by the commission. If it's contemporaneous with their participation, they would be paying at the time they participated.
If at the time they participated, the 3% cap had not been reached, then they wouldn't be paying anything at the time that they signed up, right?
Well, again, that depends. I mean, the way EPE has defined this is to identify an amount in terms of a rate that if the credit exceeds that amount on top of the avoided cost piece, then there's an amount of credit exceeding the subsidy, and that would be recovered from subscribers. And then that number would, with some small exceptions as we go through time and cost change, would not change over the course of the program because we calculated it specifically for full adoption of community solar.
But if the program were to expand and there were to be additional capacity, then those costs could go up, couldn't they?
again, if, yes, if the subsidy exceeds the cap.
Okay, thank you. And, okay. And so at the time that the customer signs up, they won't know whether the commission is going to increase the capacity of the program. So they won't know if these costs are going to hit them or not. Right?
I agree they would not know any of that, including they would not know if there was any amounts over subsidy.
Okay, thank you. All right, I have one last short line of questioning here that has to do with the combined customer disclosure and consent form, which was included in SPS's direct testimony, but I believe which all the utilities are supporting per the last settlement in the phase 1 portion of this proceeding. Do you agree with that?
I'm sorry, I got confused on your question. What are you asking him to agree to?
Just that the combined customer disclosure and consent form is contained in SPS's proposal, but that EPE also supports it.
Thank you.
If this was from the settlement in phase 1, then yes.
Okay, thank you. And this form is intended to do two main things, right? The first one is to provide relevant information to subscribers about their subscription, right?
Yes.
Okay, and the second purpose of the form is to allow the subscriber organization to access the subscriber's private utility billing and usage data, right?
Can you direct me to a section? I believe that's the case with respect to what's required for us to provide to the subscriber organization under the CSA.
Okay, that's good enough for me. So the proposed form currently requires the community solar project name, correct?
Okay, yes.
Here it is. Okay, and Mr. Barnes opposed requiring this field in order to account for adjustments and project development and interconnection timelines. You're aware of that, yes? You responded to it. Okay, I'm going to move to my next question. That's okay. You don't need to answer that. So you state at page 41, line 11 of your rebuttal testimony that you oppose Mr. Barnes's recommendation to remove the project name field because it would reduce transparency for customers as to what organization is operating the program in which they are subscribing. Correct?
Yes.
Okay, so your concern is basically that the customer might not have a clear picture of who to go to if they have questions or concerns, right?
Yes.
Okay. All right, let's take another look at this form. Would you agree with me that this form requires the subscriber organization name to be listed?
Yes.
Okay, and it also requires the subscriber organization to list their contact information and their phone number, correct?
Contact information, yes, I see that.
Okay, great, and there's telephone number.
I'm sorry, yes.
Okay, and so if the subscriber had a question or was confused about their subscription, they would know who to contact, right?
Yes, but if the subscriber organization had multiple projects, they wouldn't know which project they were participating in.
the subscriber wouldn't necessarily know what project they were participating in, right? And you just acknowledge that the subscriber organization could have multiple community solar projects, right?
That's my understanding. Yes, it's possible.
Okay. And is it reasonable to assume that those various projects might have different timelines for coming online?
And prices, yes.
Okay.
Can we conclude cross-examination, Mr. Schlesinger? How many more questions do you have?
I have two more questions, Your Honor.
Right.
You also opposed Mr. Barnes' recommendation of removing the subscription size field in this form, correct?
Yes.
Okay. And as we talked about just a moment ago, one of the reasons that a customer would fill out this form, I'm sorry, let me back up for a second. You're aware that the rules require a limitation on subscription sizes to be sized no more than 100% of the subscriber's annual average electricity consumption, right?
On an energy basis, yes.
Okay. Do you think that most customers know what their average annual energy usage is?
If they want to know, yes.
You think they know that off the top of their head?
No.
Okay. And again, this form would allow the subscriber organization to gather that data for the customer, wouldn't it?
I was thinking this form was they were gathering the data from the customer, but maybe you could refresh my memory. Who's filling out the form?
Well, you agreed with me that part of the reason that a customer fills out this form is to allow the subscriber organization to access their private utility usage data, right?
A portion of it, yes. The relevant data, yes.
So once they fill out this form, the subscriber organization could help them figure out what their average annual energy usage is, right?
If that's one of the components that they're accessing that we're providing, yes.
Okay. Thank you. I have no further questions, and I appreciate your indulgence on the time, Mr. Hearing Examiner.
Okay, thank you. Right now I have 10:23 on my clock. I think it makes more sense to go ahead and take our 10-minute break now. And when we come back, City of Las Cruces and NEE will have their cross-examination time. Let's go ahead and break until 10:35. And Madam Court Reporter, is there any clarifications you need at this point?
No, thank you, Mr. Hearing Examiner.
All right, let's go. Let's take our break. We'll be in recess until 10:35. Okay, I have 10:35 on my clock, so let's get everybody back. Okay, witness and counsel are back. Madam Court Reporter, are you ready to begin? Nodding approval. Let's go back on the record. Next for cross-examine, we have City of Las Cruces that requested 25 minutes.
Thank you, Mr. Mueller. Good morning, Mr. Schiestel. You know, this is a rare opportunity for me not to be first in cross-examining you, but it turns out that Mr. Schlesinger, oh, you just moved a little bit. Mr. Schlesinger didn't ask my questions, so I'm going to have to move along here fairly quickly. There'll be some similarities, but not the same. You're familiar with the Community Solar Act, aren't you?
Yes.
And that statute doesn't define avoided costs, does it?
No, I don't believe so.
And it doesn't define unavoidable costs, does it?
Correct. Those aren't included in the definitions.
So the company's position in this case, proposal in this case, is based on its proposal to define those terms. Is that right?
Yes, we define those terms in our proposals, yes.
And those definitions aren't in the rule either, are they?
I don't believe so, no.
I'm turning to your rebuttal testimony at page 32. I'm at lines, line 8, beginning the question, the middle of the answer that begins on the sentence that begins on line 18 and carries over onto page 19. The CSA your testimony is the CSA clearly contemplates cost responsibility for both non-subscribers and subscribers. So tracking of the total cost of bill credits not related to any particular component is reasonable and prudent in developing the program. When you're talking about bill credit, when you refer to bill credit cost, you're talking about foregone revenues to the company, aren't you?
Right. The cumulative amount of credits provided to non-subscribers.
So
to subscribers.
So it's really lost revenues, not specifically costs.
Well, right. The cost of bill credits in revenues that aren't recovered. I would agree with that.
Is EPE anywhere proposing to track the actual costs of serving community solar subscribers?
Well, we do that just normally in our cost of service.
Will you, in your cost of service, will you be?
I'm sorry, Anastasia. Mr. Schiestel, can you repeat that? That I didn't catch the last part of your answer there.
Certainly, I said that we track the cost of service for those customers in our larger cost of service. So when we develop rates, for example, and base those on cost of service, that's where we do that calculation.
Thank you.
And for your next cost of service, your next rate case, will you be tracking community solar customers, participants as a as one or more new rate classes?
No,
Wouldn't that be the way to determine the cost of serving community solar?
I don't believe so, no.
And is EPE anywhere proposing to track the benefit of costs savings derived from having 30 megawatts of capacity added to its system at no direct cost to the customers or the company?
Well, I think there you're basically referring to the actual avoided costs.
And is the answer yes or no, that you will be will you be tracking the such avoided costs related to adding that capacity?
Well, when you say tracking, do you mean recording in the regulatory asset, or just are we going to know what those total avoided costs are?
Well, your testimony is that you'll be tracking data in order to have a request in the future for recovery, correct?
We'll be tracking the total cost of the bill credits, yes.
And that's a fairly simple number, isn't it?
Yes.
And that's just foregone revenues, right?
If you want to call them that, that's fine. I'm just saying we'll have a data field that we can add them all up and say, here's the total amount of credits provided to subscribers.
Okay. So is the company planning to quantify in any way for its next rate case, general rate case, the benefits of or cost savings derived from having this 30 megawatts of new capacity added to its system?
That would be the avoided costs. So yes.
And how will you determine those avoided costs? Are we back to simply fuel and variable O&M?
Yes.
No other, you're not making any attempts to identify larger scale costs or longer term cost savings?
We would be identifying only the avoided cost in the test year.
And returning to that testimony here, well, actually the same answer on page 32, question 48, going from 32 to 33. On line 16 to 18, you testified tracking of bill credit costs, whether they are net of avoided costs or not, allows for the proper separation for cost recovery. If that process is done in the future, what does that clause, if that process is done in the future, refer to?
Sorry, I muted my microphone because of that noise. I don't know if you all heard that, but that was here in the next room. The reference to if the process is done in the future is to the treatment of the proposed regulatory asset. So to the extent we're recording those costs in a regulatory asset for consideration later, that's the future reference.
And does that clause, does that imply that there's an alternative on the table?
Well, it's certainly for the determination of the commission to decide when that cost recovery process is done. It could be done in the present based on estimates, but this refers specifically to our proposal for regulatory asset treatment and the future determination of the cost recovery.
And if I could take you back to page 31 of your rebuttal testimony at lines 15 through 20. Is that what you're referring to? Particularly lines 17 to 20. Are you with me?
I see that, yes.
Yeah. You seem to be suggesting that the commission might determine preliminary rate rider amounts? Are you suggesting that there's a, is EPE proposing a preliminary rate rider mechanism in this case?
I think I did say that the commission could set that preliminary amount as everything over avoided cost, yes.
And has EPE made a proposal for that sort of recovery?
No, our proposal was for tracking of as a regulatory asset and treatment of, or consideration and treatment of that amount later. But I believe one of the other utilities proposed and maybe even staff proposed a contemporaneous recovery with reconciliation later.
So in this case, EPE hasn't proposed a tariff and there hasn't been notice to EPE customers of a charge. It has there.
If you're referring to the recovery of what we're tracking in the regulatory asset, what we propose to track in the regulatory asset, no.
Let's go to the regulatory asset then. On page 31 of lines 8 through page 31. Oh, your question actually your question seems to be more of a testimony than your answer. And I'm looking at lines 6 through 12. Is that your testimony, the question about Ms. LaRock's position? Or is that somebody else's characterization? Let's just put it there. I'm looking at that very long question, 46.
Yes, I see it.
Is that your characterization of Ms. LaRock's testimony, or is some mysterious questioner who is not I?
No, this is my characterization of her testimony.
And your characterization is that there's nothing ambiguous about the company's various testimonies regarding a regulatory asset. Is that right?
Right. I say I don't agree there's anything ambiguous about what EP is proposing, given it is three people saying the same thing somewhat differently.
And would you please refer to open CLC exhibit number 1, Ms. LaRock's testimony? I need to do the same.
Give me 1 second.
I need.
Okay.
And I'll ask you to refer to page 21. Would you read aloud, please, the sentence that begins on line 4 of page 21?
Page 21, line 4 starts, each witness's testimony can be read to imply different degrees of certainty regarding the company's entitlement to future recovery of the amounts it seeks to record.
So do you agree that Ms. LaRock expressed concerns about the degree of the company's certainty or entitlement to recovery, not the amounts that EPE is proposing to record? Mr. Schiestel?
I wanted to read the entire answer. Can you ask your question again?
Yeah, is her point, does her point go to the degree of certainty regarding the company's entitlement to recover recorded amounts, not the amounts that the company is proposing to record?
Objection is, I think we're all a little bit confused. Is this a compound question? Are you asking about Ms. LaRoque's testimony or what Mr. Schiestel interprets Ms. LaRoque's testimony to be?
Well, I'm asking him to read Ms. LaRoque's testimony to provide his interpretation or to address his interpretation. I don't think it's a compound question.
Yeah, I think the initial question to me was whether or not he agreed that Ms. LaRoque had a concern regarding that. And then when you rephrased, which I mean he can answer to that extent, just to that he agrees that Ms. LaRoque expressed a concern. I think where the confusion came in was the second question. So let me rephrase the first question to the witness. Do you agree that Ms. LaRoque expressed a concern regarding that, regarding the testimony that had been given?
Mr. Hearing Examiner, I think that Mr. Schiestel is deliberately expending time here. And I also think your question went back a step too far. I'm asking him whether her concern is entitlement to recovery, not quantum of costs. That's all I'm asking.
I'm aware of that. I took a step back on purpose, and I'll allow you to ask that second question. And with regards to time, I'm noting. But I think I think it's self-evident that Ms. LaRoque expressed a concern in her testimony. So we can move along to your second question. Please ask the other question again to the witness, Ms. Stevens.
Mr. Schiestel, is Ms. LaRoque's concern about the degree of entitlement to recovery that is in the company's proposal as opposed to the quantum or nature of the costs that you would be recording in that regulatory asset?
I believe
Objection. Mr. Schiestel is not obligated to and doesn't have any knowledge of what Mrs. LaRoque's concern is.
He testified to it. This is his own testimony, is saying he's answering what he quoted her out, or he just explained that his characterization is lengthy and is his opinion. And then he says, I don't agree that there's anything ambiguous. That he is already opining on her testimony. And I just want to take it down a little narrower.
Okay, I think we understand the general concern here as to I think if we simplify the questioning into what he felt was ambiguous when there was allow him to elaborate what he felt was ambiguous. If there was a concern, the concern expressed by Ms. LaRoque as to the ambiguity.
Why don't I just move on with the next question, which is going back to, may I, Mr. Miller?
Yes, I'm just kind of, I understand the point that's being made, Ms. Stevens. If we could move along, that would be terrific.
Yeah, okay. So, that same answer is on lines 31 of your rebuttal, lines 13 to 14. You say, I don't agree there's anything ambiguous about what EP is proposing, given it is three people saying the same thing somewhat differently. Is it true, Mr. Schiestel, that EP has 4 witnesses who testified about regulatory asset?
Yeah, I think EP's 4 witnesses all mentioned the regulatory asset.
And are you implying here that 3 out of the 4 said the same thing and one of them said something different?
No.
Okay. So let's explain, let's have you explain to me what you believe, since you're the vice president, I guess so is Mr. Hawkins, what the proposal that the company is making. First, EP is asking for an accounting order, isn't it? That's in your direct testimony at pages 7 and 18, in your rebuttal at pages 31 and 37.
Can you give me the direct page again?
7 and 8. Mr. Schiestel, are you familiar with your own testimony?
Yes.
Okay. It's at 7 and 18 and rebuttal at 31 and 37, but are you asking, is the company asking first for a quote unquote accounting order?
My testimony is that EPE is proposing an accounting order to create a regulatory asset for tracking, deferral, and recovery of the subscriber bill credit amounts that exceed avoided costs of generating electricity, plus accrued carrying charges at EP's approved weighted average cost of capital until the future general rate case.
And what does an accounting order mean, in your opinion?
It means that the commission allows us to establish a regulatory account for the tracking.
And what assurances of future recovery does the requested accounting order bear?
I think that's a better question for Ms. Borden. But I think the assumptions around regulatory assets and their recovery are pretty standard and well established.
And are you familiar with the commission's orders in which they talk about 4 types of regulatory assets?
No.
And did you participate in EPE's case, which I can't quite remember the number of, in which the company asked for a regulatory asset to track the cost of its participation in the Western Energy Imbalance Market?
I recollect that request and its approval, yes.
And do you recollect that in that case, the company discussed the previous cases in which there are different levels of certainty implied by different regulatory assets?
No.
Well, then I'll move on. And I get Mr. I don't have it on the list, but of the list of, at the end of my testimony, I'd like to ask to take administrative notice of the order in that case, which right now is eluding me, the number. I'll find it shortly, but I'd like to keep going. So, on page 37 of your direct testimony, Mr. Schiestel. I lost you.
Do you mean rebuttal?
Your rebuttal, yes. Page 37 of your rebuttal. Would you look at the question and answer, but that begin question 54 and the answer?
Okay.
And is it your position, the company's position through you, that what you're asking for here is not a pure accounting order by which EPE may only record costs to request recovery in a future case?
That's what I have in the question, yes.
And your answer is that you're, no, I'm saying that the question refers to pure accounting order, and your answer is, the gist of your answer is that the company is not asking only for a pure accounting order in which questions would be resolved in a future case. Is that right?
Objection. Mr. Schiestel is not, counsel has not defined what she means by pure accounting order.
If he's also explaining.
To the extent, hold on, everybody. All right, first of all, let me clarify one thing. Once you make an objection, wait for me to respond to you before proceeding. And after that, I'll afford any response from the other party. So to simplify that, to the extent that the question asks the witness the gist of his testimony, I'm going to say that he can clarify what the gist of his testimony is. So to the extent that your objection kind of contains that, the witness would be allowed to answer that since the question was phrased like that. So I'm going to allow the witness to answer on his own accord there.
Okay, in my answer, I say that the factual basis for the cost recovery is provided by the CSA. So I was responding to, I think, a characterization of what we're recording as a regulatory asset as there being no factual basis for cost recovery, and I think there is.
Well, let's follow up then with Mr. Goldberg's questions. Or are you opposing the commission treating this, or let's look at the question and the answer. Is it the company's position that they oppose treating this as a pure accounting order, by which EPE may only record costs to request future recovery?
Well, we're requesting a regulatory asset. If you have more detailed questions with respect to accounting, we have an accounting witness specifically to address those questions.
And then what should we do with the fact that you included this question and answer in your testimony?
I believe it stands on its own.
So is it the company's position that the legal and factual basis for some sort of assured recovery is provided by the Community Solar Act?
Yes, the basis for cost recovery is provided by the CSA. The determination of what cost in total should be recovered is a determination by the commission in a future rate case.
And is it the determination of and this regulatory, so you're asking for a regulatory asset. If that request were granted by the commission, what is EPE's understanding of what that would guarantee the company of having the opportunity to provide a rate mechanism for in the future?
What we're requesting is to record costs in a regulatory asset to then address recovery of those costs in a future proceeding, a future rate case. I'll give an example of, say, a potential amount included in the regulatory asset that ultimately isn't allowed for recovery. If in the future, in that rate case, for example, cost associated with a disallowance, for example, that the commission makes that determination, there's a disallowance, and those amounts were included in that tracking, then they wouldn't be recovered as part of from the regulatory. They'd be removed from the regulatory asset amount prior to recovery.
And let's get more specific about this regulatory asset, because my understanding is that this regulatory asset is founded on revenue. You just had your earlier testified, it's founded on foregone revenues under existing rate schedules. Is that right?
Well, I think you characterized it as foregone revenues.
You agreed. So how would what level would the commission be able to disallow those because they are revenues, or would the commission only be able to disallow those because, for example, a particular, you measured the customer base wrong?
I was attempting to give a broad example and I'll leave it at that.
Let's try to, I'm asking you to give a narrower example, Mr. Schiestel. Given the nature of the cost that the so-called cost that you're putting into this regulatory asset, what would the commission be able to disallow under your proposal?
I don't have any specific examples. That would be for the commission to decide.
And if the commission were to disallow all of it, would you consider that to be consistent with the company's request?
No.
Why not?
Because the CSA provides for recovery of those costs.
But we don't know what those costs are, do we?
Not until we get to the requested recovery.
And are the categories that you are requesting to recover in this case the foregone revenues offset by fuel and variable O&M? Are those all up for grabs in the next rate case? Can the commission disallow those amounts?
The amounts that we'll be tracking and proposing recovery for in the future are what we've identified in our application as unavoidable costs. That is, we incurred the costs. We incurred those costs, but didn't recover them yet. And so we would recover them in the future.
So when you just said that word, we would recover them in the future, is it your opinion and your request that the regulatory asset that you're requesting in this case guarantees you recovery of revenue, what you call lost, what I'm calling foregone revenues, what you're calling billing costs, less what you call avoidable costs? Is that going to be guaranteed recovery through the nature of the regulatory assets that you're proposing here?
Again, I think that's a determination by the commission in the future.
Is the commission determining none of that in this case? Let's look at it the opposite way. Let's focus on this case. What are you asking the commission to determine in this case?
We're asking the commission for an accounting order to record certain costs as a regulatory asset for consideration in the future.
For consideration in the future. And consideration, does that mean the commission can say no in the future?
My characterization of or use of the word consideration means who are those costs? Where does that cost recovery come from? Obviously, the commission can make a different determination.
I just want to say, Ms. Stevens, if you could wrap up your cross-examination here.
Okay. What would EP have to prove in the general rate case in order to be authorized in some manner to recover the amounts that it records according to its proposal in this case?
I would say it would be to demonstrate that the costs that were recorded in the regulatory asset were associated with costs that the commission had previously authorized recovery of. So to the extent those unavoidable costs, which are not recovered in the defined period, whatever it is, test year, were costs that were approved by the Commission for Recovery, I think that would establish that those costs should subsequently be recoverable going forward.
And Mr. Schiestel, I'm going to mostly ask Mr. Carrasco this, but let me just start with you. Is it true that EPE's load has grown since the rates were set in the last general rate case?
Yes.
And is it possible, and is the EPE's New Mexico loads continuing to grow?
Yes, we have load growth year to year, yes.
And would the availability of this 30 megawatts of solar energy make it possible for you to serve some of that new load growth without adding or procuring 30 megawatts of capacity at a cost to the company and its current ratepayers?
No.
Why not?
Well, because of the nature of solar generation, the 30 megawatt nameplate isn't necessarily what's provided at peak, which is really what drives our need for new generation capacity.
So the 30 megawatts of community solar will provide some peak capacity, will it not?
It may.
It may. Are you expecting that all of those 5 or 6, I guess it's 6, roughly 6 facilities are all going to be down during, or not generating a single kilowatt of energy during EPE's peak hours?
That's certainly a possibility.
Would you like to elaborate on what scenario would show that no generation was coming from any of the 6 units during a summertime peak? You do peak in the summer, right?
We frequently see solar generation down in the summer due to overcast skies.
Completely down, not generating a single kilowatt hour?
Certainly down to the point of negligible.
And turning to energy, are you suggesting that those 6 new community, 6 or more solar community facilities will produce no energy, contribute no energy that you could use to serve other customers during the whole year?
Well, that wasn't your first question, but I certainly wouldn't expect them to never produce energy in the year. But we were talking about their operation at peak.
Okay. And one last question. I know I'm over. How does the pending appeal of Rule 573 affect the proposed regulatory asset in this case?
I don't believe it does. It may affect the determination of cost responsibility for the costs that are recovered or that are tracked in the regulatory asset. But the costs remain the same with respect, say, for example, to transmission costs, unavoidable transmission costs, but it may affect cost responsibility between subscribers and non-subscribers.
I think that's it. Thank you, Mr. Schiestel.
Thank you.
Okay, next up for cross-examination, we have NEE, who changed their requested time to 45 minutes from the prior 25 this morning, switching that for Mr. Babé. NEE, please proceed.
Thank you. Good morning, Mr. Schiestel.
Good morning.
In 2021, EPE was involved in the legislature when the consensus bill was introduced and passed as the Community Solar Act, correct?
Yes.
The Community Solar Act included many of the investor-owned utilities demands. Is that also correct?
That I don't know.
Were you specifically involved in the negotiations?
No, I was not. Our individuals in our governmental affairs group were, but no, I wasn't directly involved.
You know, for instance, that the IOUs wanted to limit the individual solar array project size from 10 megawatts to 5 megawatts maximum.
Yeah, I don't have knowledge of that.
Do you have knowledge that the IOUs, which stands for investor-owned utilities, wanted and got a limitation on the overall size of the program from no cap to 200 megawatt total cap for all 3 IOUs?
I recollect the cap discussion, yes, but I wasn't part of it.
And were you also aware that one of the other considerations that was ultimately decided in the Community Solar Act was that it permitted participation by investor-owned utilities to be a subscriber organization?
Yes.
And that the IOUs would be permitted ownership of the renewable energy certificates associated with a community solar facility?
For all of the community solar facilities, yes, in their service territory.
You would agree that the act required the PRC to administer and enforce the rules and provisions of the act, including regulation of subscriber organizations in accordance with the act, and oversee and review consumer protections established for the community solar program?
Yes.
Would it be fair to say that the purpose of the Community Solar Act is to encourage the conversion to solar energy from energy derived from coal and gas by allowing communities, businesses, and neighborhoods to directly invest in solar, connect to the grid, and receive a credit on their bills for the solar that is generated resulting from their respective subscriptions?
Objection. It's a
Yes, Mr.
compound question.
Goldberg.
It's a compound question.
Yeah, and Mr. Nanasi, are you reading from the act, or where are we getting that quote from, just so I can kind of follow along?
The previous question was, but this is a broader question about the purpose of the Community Solar Act. And yes, it is a compound question, but it's because I'm trying to have a meta understanding that that's the purpose of it.
Okay, I mean, to the extent that the Community Solar Act, the act itself contains that language, let's take notice of that. But if you know, let's break it down so it's not compound.
Okay, thank you. Would it be fair to say that the purpose of the Community Solar Act is to encourage the conversion from fossil fuel energy to solar energy in general?
Well, I'd certainly say that's the result. My interpretation and in participating to the extent I did with this and prior attempts at community solar is that the program gives customers an opportunity to get more renewable energy and replace obviously the energy from the utility that may otherwise be supplied by gas resources or coal or whatever. Certainly that's the that's my read of the intent of having a community solar program.
And it allows communities, businesses, and neighborhoods to directly invest in solar and connect to the grid, and also to receive a credit on their bills for the solar that is generated. Is that also true?
Not to quibble, but to the extent that investing means participating and paying subscription rates, yes.
You would agree that the Community Solar Act allows greater access to thousands of New Mexicans, regardless of income or ability, to install rooftop solar to access the benefits of solar.
Yes, I think that's actually the primary motivation for community solar, is to provide that opportunity for those who don't otherwise have access to it, say through rooftop solar.
How many states have passed legislation similar to New Mexico's with the objective of enabling and encouraging community solar facilities?
I don't know.
Is it about 20?
I will say I understand it's considerable. I know of California in my experience, but yes, that's my understanding, is it's a significant number of states.
Would it be accurate to say that it took advocates around 8 years to pass the Community Solar Act?
I don't know how long it took. I will say that we established a community solar program in Texas without a statutory requirement. So I think they can exist without state law either requiring them.
But you are aware that there were a number of years that advocates were trying to get community solar passed at the legislature before the actual passage.
Yes, my recollection is it was at least 3 sessions that community solar was proposed.
And El Paso Electric opposed that legislation before the 2021 Community Solar Act adoption. Is that also correct?
That I don't know.
The act required the PRC to adopt rules by April 1st, 2022 to implement the community solar program required by the legislature. Is that true?
I believe that's in the act, but I don't have a clear. If you have a reference, I can confirm it.
Well, subject to check, would you agree that the act required the PRC to adopt rules to implement the community solar program?
Yes.
And the PRC did so via a public rulemaking process that concluded on March 30th, 2022. Is that correct?
That's my recollection, yes.
And EPE was involved in that public rulemaking process, correct?
Yes.
And the PRC did adopt rules as the legislation required.
Yes.
Those rules have been codified under the New Mexico Administrative Code 17.9.573. Is that also right?
Yes.
Also pursuant to the Community Solar Act, the commission was to provide rules with respect to a community solar bill credit rate mechanism for subscribers derived from the qualifying utility's total aggregate retail rate on a per customer basis, less the commission approved distribution cost components, and identify all proposed rules, fees, and charges.
Yes, that's included in Rule 573.
The law allows for subsidization by non-subscribers, does it not?
Contingent upon the commission determining there's a public interest in that allowing a subsidy. Yes, that's how I understand the CSA.
determining the community solar bill credit mechanism for subscribers and the calculation of the 3% subsidization limit for each of the qualifying utilities are purposes of this hearing, correct?
Yes, I recall that those are purposes laid out for phase 2.
Would you agree that the rules adopted by the PRC contain no novel or unusual provisions as compared with community solar regulations in other states?
I don't know.
Could I have 1 minute, Your Honor, or not even, but 15 seconds?
Sure, go ahead.
Thank you. Could you please pull up New Energy Economy's demonstrative exhibit A, which is the administrative code 17.9.573, and could you please turn to section 20?
I have it. One sec. Okay.
So I highlighted this. You see that in front of you, correct?
Yes.
Okay. Could you please read 17.9.573.20 subsection D?
The utility shall not subtract any costs of transmission from the solar bill credit rate calculation.
The rules exclude transmission costs from the solar bill credit calculation, right?
I'm sorry, the rule includes transmission in the solar bill credit calculation. Yes.
EP appealed the rulemaking to challenge Rule 573's prohibition on utilities including any cost of transmission from the solar bill credit calculation, among other things, correct?
That's my general understanding of the appeal. One of them. One aspect.
You know, I'm sorry?
I was just at one aspect of the appeal, yes.
Okay. You know that in the appeal, SBS filed a motion to stay the implementation of the community solar rules.
Yes, I'm generally aware of that. Yes.
And New Energy Economy and a few of the entities who are interveners here, like the city of Las Cruces, the Coalition of Sustainable Communities, etc., opposed SPS's motion for stay in the community solar rules, correct?
I don't know the appeal in that to that detail.
But you do know that just yesterday, the New Mexico Supreme Court denied SPS's motion.
No, I wasn't aware of that.
Would you agree that solar on building rooftops serving households or businesses and community solar projects has been shown to decrease the cost of reducing carbon emissions from the electric grid?
That's a little convoluted, but if you're asking me if those contribute to reducing emissions, I would say generally yes, to the extent that they replace energy that would otherwise be supplied by carbon emitting generation.
Can you please turn to EPE Exhibit 1, which is your direct testimony at page 13.
Okay.
and also, 14 as well. So I'm focused right now on the end of page 13 and the beginning of page 14. At the top of page 14, you state that it is EP's position that the commission's failure to include costs of transmission in the solar bill credit calculation is unlawful, correct?
I don't think you're reading from my testimony. I'm sorry. At least not, redirect me on a page. You said my direct testimony?
Yes, on the bottom of page 13, the top of page 14, it's all about the cost of transmitting power to customers. That's what this section of your testimony is talking about. And then specifically, so going to starting on, I'll just read line 18, page 13 until page 14. And that, I think you say, as previously mentioned, Rule 57D3 prohibits utilities from recovering the cost of transmitting power to customers that subscribe to the CS program, which you're referring there to community solar, correct?
Yes.
And the utilities, including EPE, are appealing that prohibition because it results in the unlawful subsidization of transmission costs by non-subscriber customers. Did I read that correctly?
Yes.
And so I believe that you ended your cross-examination with Ms. Stevens, and I didn't write it down exactly, but basically, if the Supreme Court denies the appeal from EPE, SPS, and PNM, that means that those transmission costs are not recoverable by the utilities for community solar projects, correct?
No, I think the only determination there is whether or not transmission is included in the bill credit rate or not.
And so if your appeal is denied, that means the PRC rules are upheld, correct?
I don't know the appeal to that extent. I'm referring here just specifically to this question around whether or not transmission costs should be included in the bill credit rate.
And it's EPE's position that it's an unlawful subsidization of transmission costs by non-subscriber customers, right?
Well, it could result in that if non-subscribers had to pay transmission costs that are properly paid by subscribers.
But when you say properly paid, that determination is the commission's determination, not the utilities, right?
To some extent, yes, except that the CSA limits the amount of subsidy that can be provided by non-subscribers.
EP filed numerous motions about including the recovery of transmission costs from customers that subscribe to community solar programs before the commission, right?
Well, I don't know the number of motions that we filed. We certainly have taken the position that including transmission in the bill credit rate it results in non-subscribers paying for those transmission costs.
But you lost that argument, right? That's what your appeal is about.
No, I don't believe I would characterize it as losing the argument. even if the transmission costs are included in the credit, there's still a question of how the cost of those credits is distributed between subscribers and non-subscribers.
Is it EPE's intention to try and recoup transmission costs by including those costs via another mechanism anyway?
Yes, as a practical matter, they will be recovered in some fashion.
And EPE's proposal is to collect in its next rate case what it deems fixed transmission costs from community solar subscribers in what it is calling a quote recovery charge, right?
Well, again, then we go back to the distribution of that cost recovery across subscribers and non-subscribers. I will say it's our position that transmission costs should properly be recovered from subscribers.
Has EPE performed a hosting capacity analysis in this case or any other case for the commission to see?
I don't know that. Mr. Hawkins might.
If it's EP's position, it's EP's position that transmission costs are unavoidable, correct?
It's EPE's position that transmission costs are not reduced as a result of a community solar program. The costs remain the same.
But there's no evidence other than your testimony about that, is there?
Well, as a practical matter, the transmission cost recovery that's approved by the commission is currently reflected in our base rates. So certainly, if that cost recovery is reduced, we are not recovering what the commission has otherwise allowed us to recover for transmission costs, at least as it's reflected in base rates. So in the current year, that's the case.
And isn't the way that a customer is charged based on usage?
Some customers, there's customers that have both volumetric or usage-based charges and demand-based charges.
How many of EPE's New Mexico customers are residential customers?
The large majority.
Do you have any idea like what the percentage is?
I don't recall exactly. I will say
Okay, but what about not exactly? Just give the commission a relative idea.
70%.
And those residential customers are charged based on usage. Is that correct?
Volumetric charges, yes, per kilowatt hour charges. But energy or usage is not the driver for transmission costs. So what drives transmission costs is the peak demand, coincident peak demand on the system. It isn't how much energy is flowing on the system.
And solar is a very good match with peak to address peak demand, is it not?
No.
Do you know if P&M or SPS performed a integration capacity analysis?
No.
Had EPE performed a integration capacity analysis, wouldn't that help prove or disprove whether community solar projects will use the utilities transmission system?
I don't know.
It would demonstrate where grid capacity is abundant, though, wouldn't it?
I really don't have knowledge of those analysis. I can't answer that question.
Pursuant to the Community Solar Act, specifically 62-16B-7, the PRC was to establish a process for the selection of community solar facility projects, right?
Can you give me, I apologize, can you give me the section again? I have it in front of me.
62-16B-7. Sir, I really can't wait to spend any more time. You know that the PRC did select certain community solar facility projects within the guidelines of the statewide megawatt cap for utilities, right?
Yes.
What are the business names of the awardees of the community solar facility projects within EPE's geographic territory?
I'm sorry, I missed the first part of that question. What are the what?
Business names of the awardees of the community solar facility projects within EPE's geographic territory.
I don't recall the business names. I know I looked at the list, but I don't recall the names.
None of those projects have actually been interconnected, have they?
I don't know. I don't believe so, but I don't know for certain.
Did EPE recently inform developers that the interconnection timeline has been delayed for more than 20 months?
I don't know.
Do you know that simultaneous with EPE's delay, both PNM and SPS have also announced a nearly 2-year interconnection timeline delay as well?
No.
What is the alleged justification for EPE's interconnection timeline delay?
Objection.
Mr. Goldberg.
Mr. Schiestel has already established he does not know about the delay, and she keeps pressing him on it.
Mr. Nanasi, response?
I don't think that's an objection. There's no legal basis for that. This is my last question on this subject.
Okay. To Mr. Goldberg's point, I don't, if he has no knowledge of the delay, I don't think he's going to be able to offer a response to the question, but your question is noted on the record.
Mr. Hearing Examiner, I would like to ask Mr. Hawkins some of the questions about the hosting capacity analysis, since Mr. Schiestel said that he is the appropriate witness to answer those questions. And so if it's okay, I would like to stop my cross-examination now. I think I have about 10 minutes left. And if I could somewhere between 10 and 15 minutes. I don't know exactly when I started, but if I could take that time to probe that with Mr. Hawkins, which I believe is an important topic for this commission to understand.
Okay, if you are ceasing your cross-examination now, I will allot that amount of time for Mr. Hawkins. I have no issue with that.
Thank you. I really appreciate that because I did say that I would waive it, but I didn't know that Mr. Schiestel wouldn't know the answer to this. So thank you. And that concludes my questions.
Okay, thank you. Mr. Black, you requested 10 minutes.
Thank you, hearing examiner. Good morning, Mr. Schiestel.
Good morning. Still. Just morning.
Thank you. Let's see, I'm referencing EPE Exhibit 1, which is your Phase 2 direct testimony. At page 16, lines 2 to 4. There's a question there, and then you answer it on line 16, beginning at, on page 16, beginning at line 6. Basically, you indicate there that one of the issues to be addressed related to the implementation of the communities for community solar is that EPE must facilitate, quote, interconnection of the selected community solar facilities in the utilities service territory to the utilities transmission system. Not distribution, but transmission system. Do you see that?
Yes.
Okay. Subject to check. Do you believe the Community Solar Act at 62-16B-3, Section A, subsection 2 states, a community solar facility shall, 2, be located in the service territory of the qualifying utility and be interconnected to the interconnected to the electric distribution system of the qualifying utility. There's a similar a passage in the Commission's Rule 573 at, where is it? 17.9.573.10A2, be located in the service territory of the qualifying utility and be interconnected to the electric distribution system of that qualifying utility, not the transmission system. Can you explain? Excuse me. Can you explain your language on page 16, lines 6 through 7, where you refer to facilitating interconnection of the selected community solar facilities in the utilities service territory to the utilities transmission system?
Yeah, I mean, it appears that I misstated that in my testimony. I certainly agree that I found the section and I appreciate you giving me the section of the rule because I was struggling with the statute. But yeah, it appears that's inconsistent with 10A 2.
Would you offer to make a change to your testimony and say distribution system rather than transmission system? But just think about that. That's not really a good question here. But let's go ahead and ask my questions then. So for EPE, is it a requirement that a community solar facility must interconnect with the company's transmission system?
Well, I'll just say that I don't think that we could require that under the CSA and the rule. I think that's just a misstatement on my part, but I will look into it.
Thank you. So is it possible that the community solar project can interconnect at the distribution level?
I think that's the requirement, at least as I read the rule.
Okay. All right. Have the selected community solar facilities completed the interconnection process for EPE?
I don't know.
All right. All right. Would you know whether some of the selected community solar facilities have been unable to reach the construction or interconnection stages?
I don't know.
All right. I guess I wanted to follow up to our previous question. How did EPE determine that community solar facilities must be interconnected to the transmission system? And well, you kind of explained that a little bit. Yeah, it was a misunderstanding. But assuming that is true, assuming it's interconnected at the level of distribution system, yes, the distribution system. Were there stages contemplated at what stage of project development should community solar facilities be interconnected to the distribution system?
Well, I'm not sure I understand your question, but certainly to become operational and provide energy, they would be interconnected to the system.
Okay. All right. Would you know if a community solar facility that was in line forfeited its selection, whether or not the third-party administrator could select an alternate project?
I don't know.
All right.
I would assume that the cap amount, the total cap, is the limitation, and to the extent there's available capacity, then other systems could be selected.
Okay, so just to recapitulate, the community solar facilities can connect at the distribution level.
That's certainly the way I read the rule, yes.
And you would know if there's any engineering problems with that, or any other problems that would prevent that?
I don't know, but I don't think so.
Okay, all right. Okay, now I'm going to switch over to your rebuttal testimony, EPE Exhibit 2, please. And if you could go to question 8, which is starts on page 4. Let me pull it up too.
I'm sorry, Mr. Black, would you mind just repeating the page number?
Yes, of course. We're at EPE Exhibit number 2, page 4.
Thank you.
You're welcome. And the question is about City of Las Cruces witness Lisa LaRock framing her evaluation of the utilities community solar bill credit tariffs. And she does that in her testimony on page 32, lines 13 through 17 is what the question says of her direct testimony. And she states that the utilities, quote, are not supportive of the Community Solar Act. And then further on down on line 15, it continues, do you believe that accurately reflects EPE's views of the community solar program and EPE's attitude towards its community solar bill credit rates? Did I characterize that correctly?
Yes.
Okay, going to page 5. you answer in relevant part, beginning on line 8. EPE had procured a site within Las Cruces for the community solar facility and had a waiting list, etc. Then it goes on down, starting at page line 14. Unfortunately, EPE ultimately withdrew its application in response to considerable opposition from the city and NEE. Do you see that?
Yes.
What was that opposition?
So this is referring to the community solar program that we proposed in New Mexico in 2018. And essentially, as I recall, the opposition was that they opposed the program.
But you didn't know the levels or the components of what that opposition was comprised?
Well, I'm sure I did at the time.
Okay.
I was the witness in the application. We never even got to a procedural schedule. We ultimately withdrew it, basically because none of the interveners or potential interveners supported it, even though we had pretty significant desire from customers for it. It was obviously going to be opposed at the commission.
Would that case number be at the top of your mind?
No, sorry, David.
Okay. That's okay. I'm sure we could figure it out. Okay, now I'm going to switch finally for my last question. Same exhibit, EPE2, question 11, starting on page 7. Line 18, and it spills over to page 8, line 2. And you give your answer on page 8, lines 4 to 5.
Okay.
So do you, I'm going to read the question 11. Do you agree with the city's recommendation for the commission to order the utilities staff and the interveners to collaboratively develop a simpler and uniform community solar bill credit rate schedule format, is the question. And then the portion of your answer that I would like to probe is, I agree there may be a portion of the bill credit tariff that could be simplified or standardized. Do you see that?
Yes.
Which portions of the community solar program do you think could be standardized?
Well, I wasn't identifying a portion. I said there may be portions of the bill credit tariff that could be simplified or standardized, which I think was the point of having this collaborative effort. But I hadn't identified specific areas. I hadn't. I think I was speaking just generally. We may be able to find areas for simplification or standardization, but my point in the response was that, you know, we all of our tariffs for all of our, I think it's safe to say, between the utilities, our retail customers differ in one way or another. And so I don't see a fully standard uniform bill credit rate is really possible across utilities in the same way that our other schedules aren't really.
All right, so I understand that you're just speaking in general terms here.
Yes.
All right, thank you so much. Mr. Hearing Examiner, in the interests of people's blood sugar, staff is finished with the cross-examination of Mr. Schiestel, James Schiestel.
Thank you, Mr. Black, and everyone's blood sugar thanks you as well. Mr. Goldberg, do you have that concludes the cross-examination of this witness. Mr. Goldberg, do you have any questions for the witness?
No, Mr. Hearing Examiner.
Okay. That concludes the testimony of this witness. The witness may be excused. Before we break for lunch, then let me just quickly review EPE's witness Borden is up next. City of Las Cruces and staff both requested 5 minutes. Let me go ahead and ask, are the 5 minutes still requested by the city and staff? Anastasia?
Yes. Yeah.
Okay, Mr. Black? You're on mute, Dave.
I'm sorry, it was for EPE witness Borden.
Yes.
We'll waive. We'll waive.
Okay. We will start with EPE's witness Borden, then Hawkins, Carrasco, and Bombay. We're going to be on a fairly tight schedule then to get through that. I will probably hold CCSA to its statement that they had consolidated their cross-examination questions, and I'll probably be a lot more non-willing to extend time this afternoon just due to the time constraints. So just to put everyone on notice of that, don't be surprised if I cut you off this afternoon. Other than that, let's go ahead and go off the record, and we will be back at 1 o'clock. Thank you, everybody.
Mhm.
Right, I have 1 o'clock on my phone if we could get everyone back. Madam Court Reporter, are you ready to begin?
Yes,
Okay. EPE, you can call your next witness.
Yes, this is Nancy Burns for EPE.
Good
And
afternoon.
good afternoon, Mr. Hearing Examiner. We'll call our next witness, Miss Jennifer Borden.
Ms. Borden, would you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon.
Good afternoon.
Can you please state your name for the record and spell your last name?
Yes, it's Jennifer I. Borden, B-O-R-D-E-N.
And Miss Borden, what is your current profession?
I am employed by El Paso Electric as the Director of Regulatory Accounting.
And is there a document in front of you marked EPE Exhibit 3?
Yes.
And can you identify that document?
Yes, my direct testimony in this case.
Filed on September 18th, 2023?
That's correct.
And are there any exhibits attached to it?
No, there are not.
Okay. And was this direct testimony written by you or under your direct supervision?
Yes, it was.
Do you have any changes or corrections to make to your direct testimony?
No, I do not.
And if I were to ask you the same questions today that are contained in there, would the answers be true and correct to the best of your knowledge?
Yes.
Mr. Hearing Examiner, I'd like to move what's been marked as EP Exhibit 3 into the record as evidence.
Okay, request is for EPE Exhibit 3 to be added onto the record. Any objection? Hearing none, it is admitted.
Thank you. I will tender Ms. Borden for any cross-examination.
Okay, and the only party requesting cross-examination was City of Las Cruces with 5 minutes. So Anastasia, proceed.
Thank you. Hi, Ms. Borden. I hope you don't hate me I didn't realize that I was the only one.
No, it's okay.
Okay, so your entire testimony is about the accounting order and the regulatory asset that the accounting order would create, right?
Yes.
And would you please refer to the question and answer on the top of page 6 of your testimony?
Okay.
Oh, where is it? Were you listening to Mr. Schiestel's testimony this morning?
Yes, I was.
Is it your position that the regulatory asset that EPE is requesting in this case, if approved, would do nothing more than merely authorize EPE to, quote, track costs in a regulatory asset account?
Yes, that's my testimony.
And does your language to the effect that quote, a commission determination on cost recovery may be made in a future rate proceeding, unquote, does that language mean that the commission's authorization in this case would do anything more than just allow EPE to record and not write off those old costs or missing revenues?
So we're requesting the accounting order to set up this regulatory asset at this time for a future consideration for the commission.
Okay, so in that future consideration, what would the commission, by granting this request, promise EPE anything in the way of recovery in the future?
Can you repeat that question?
By granting the company's request for regulatory asset as described in your testimony and everybody else's, would the commission be committed to what commitments would the commission be making to the company in terms of its entitlement to recover costs in the future?
I think it would set the fact that the commission is going to determine those costs in a future case as far as how the cost will be recovered, whether it be or how those costs will be recovered from non-prescribers and subscribers, excuse me, of the program.
So you're referring to a methodology and an allocation between subscribers and non-subscribers? Is that fair?
I mean, that's one of the determinations that could be made by the commission.
Could the commission determine that the costs that you recorded are not recoverable?
I think the determination of the commission would be that the costs that we're deferring for future recovery do meet the CSA rule.
And if you turn back to page 5 of your testimony, and that refers to case number 21-00180, which I appreciate you use the number of, because I couldn't remember when I asked Mr. Schiestel. Do you interpret the language that you quote here, beginning on page on line 12? Do you interpret that to mean that the commission has the power to fully disallow anything that the company is recording in the WEIM regulatory asset?
Yeah, as I stated before, the commission does have, we'll look at the costs and make sure that the costs are, in this case, related to the EIM implementation. So just depending on what the commission is looking at, they can decide that they make the determination whether or not those costs do comply with the specific rule in question.
The specific, pardon, I missed that word.
The specific rule, in this case, the CSA rule.
And so do you believe that the conditions of the order in 21-00180 UT apply to the present case? Well, not even apply to the present case. Do they apply to your present application for an accounting order in this case?
I think I use that as an example. Every case is different, and in every case, the commission will be looking at the specific requirements of what the rules govern in that specific case. So I think that was an example, and just depending on what the commission wording is in the order and what's decided, I think it could be the same, it could be different, it just depends.
So you said it could be the same. So does the company have a position on whether it would accept the similar constraints in an order in this case?
I wouldn't be able to answer that. I think we'd have to see what the commission order is.
Okay, that's all my questions. Thank you. And again, apologize for dragging you here.
Okay,
Good to see you though.
Nice to see you too.
Okay. Staff had waived the prior request for cross-examination. Ms. Burns, do you have any questions for your witness?
I have no redirect, thank you.
Okay. That being said, the witness is dismissed.
Thank you.
EBE, you can call your next witness, please.
EP's next witness is David Hawkins. It may take just a moment, Mr. Hearing Examiner.
Yeah, I see they're changing it.
Mr. Hawkins, this is the court reporter. May I hear a hello from you so I can judge your volume?
Hello?
Thank you. Would you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Good afternoon, Mr. Hawkins.
Good afternoon.
Can you please state your name for the record and spell your last name?
David Hawkins, Hawkins.
Mr. Hawkins, what is your profession?
I am Vice President of Operational Support at El Paso Electric, which is a change from my filed testimony. My new title took place January 1st of this year, but my responsibilities as I testify here have not changed.
Thank you. And I have a couple documents that should be placed in front of you. One is marked EPE Exhibit 4. Do you see that?
Yes.
Can you identify that for the record?
Yes, that is my direct testimony.
And are there any exhibits to that direct testimony?
No.
Okay. And was this direct testimony written by you or under your direct supervision?
It was.
Do you have any changes, corrections, or additions besides the title issue to this direct testimony?
No.
And if I were to ask you the same questions today, would your answers be the same?
Yes.
And would they be true and correct to the best of your knowledge?
Yes.
So I'd like to move what EP is marked as EP Exhibit 4 into the record as evidence.
Okay, request is for EPE Exhibit number 4 to be admitted. Any objection? Hearing none, it is admitted.
Now, Mr. Hawkins, can you identify what's in front of you and has been marked EP Exhibit 5?
Yes, that's my rebuttal testimony.
And do you have any changes, corrections, or additions to make to your rebuttal testimony?
I do not.
And was it written by you or under your direct supervision?
It was.
And if I were to ask you the same questions today that are stated in this rebuttal testimony, would your answers be the same?
Yes.
And would your answers be true and correct to the best of your knowledge?
Yes.
EP would like to move what's been marked as EP Exhibit number 5 into the record as evidence.
Request is for EPE Exhibit number 5 to be admitted. Any objection? Hearing none, it is admitted.
With that, EP will tender Mr. Hawkins for cross-examination.
Thank you. Two parties requested cross-examination time. First is City of Las Cruces for 5 minutes.
Good afternoon, Mr. Hawkins. I hope that staff has some questions for you so I don't feel like a real jerk here, dragging you here. So would you please turn to your direct testimony, page 4. And this is an answer that continues from a previous page, and then a second question and answer. And my question to you as an engineer and all sorts of other things at the company is, do Do you literally mean that the energy generated by community solar facilities will be delivered to the subscribing customers wherever they may be on EPE system in New Mexico?
I'm sorry, just so I understand the exact language, can you give me the line number?
Oh, I'm just the whole, well, specifically. Well, the whole thing really, line 2, generate what lines 1 to 2, subscriber organizations generate solar energy, which is delivered to subscribing customers of utilities. It goes on, the subscribing organizations are permitted to reach subscribing customers of EPE within relatively large geographic area. And then the next question and answer. Yes, there is no way to avoid the community solar power from moving on the EPE transmission grid. It is the only method of moving such power from the subscriber organization facilities to EPE subscribing customers. See all that?
Yeah. No.
Now, my question to you is, will EPE literally be moving electricity from subscribing facilities to the subscribers?
You know, I would say it probably, you know, if there's a facility in Hatch, New Mexico, and a customer signs up in Las Cruces, those electrons that are generated in Hatch do not end up in the home of somebody who subscribed in Las Cruces. And much like our wholesale agreements where a wind farm that Tucson owns in eastern New Mexico, that electricity ends up in Arizona.
So by having, say, half a dozen community solar facilities distributed at different points on your system in New Mexico, isn't there a possibility that the burden on EPE's transmission system will be reduced rather than increased?
I can't come to that conclusion. I mean, for example, we have 2 projects at our Moongate substation, 5 megawatts each. So total of 10 megawatts, but the maximum load on that transformer was only 5 megawatts. And so, yes, that generation, those electrons will backfeed into El Paso Electric's transmission system, for example.
So I think your answer is yes, there are some possibilities, and in some cases, yes, some cases, no.
Yeah, I think that's true, especially as it grows, right? If you look at something as 5 megawatts versus the 30 megawatts, you have to look at the whole as opposed to each individual project.
And has EPE performed any studies of the effects of adding community solar facilities on the effects that adding community solar facilities will have on its transmission system? I don't want to say, I want to make that clear that it's kind of a global effect.
Sure. My understanding is that we have performed system impact studies on each of the proposed facilities. And in those facilities, the impact in terms of additional costs are not impactful to our transmission system.
Okay. And does EP anticipate performing further studies when the community solar facilities are actually up and running? Regarding
we do
back in the system?
I mean, different types of studies. So we do real-time studies of our system, which include all the generators, look for contingency studies. So yes, I mean, there'll be ongoing studies for operational purposes typically.
And do you believe that the outcome of both sets of analyses may be relevant to determining what amount of transmission costs, if any, should be allocated to community solar customers?
Well, so relating it to the bulk power market, where you have solar facilities that look to move power either onto EPE system or across EPE system, aren't always generating, but they do subscribe, and they need to subscribe to 100% subscription to the transmission system for a variety of reasons. One, if they are taking up positions on the transmission system, they need to reserve that. Not knowing when or where, but they can't block out by hour on a long-term basis. So when they reserve it, they do reserve the full capacity of their resource on transmission systems.
And clarify for me, please, are you talking about the analogy to larger bulk system things, or are you talking about these?
Yeah, I think it's yes, to a large one, because it's very similar. We're talking about displacement, as I understand those who say our transmission system won't be used because it's generated in one particular part of the system, and therefore the energy will sink in that part of the system. What it's really doing is displacing the electron flow on the transmission system, much like a larger project would across EPE system.
And one last question. So in terms of rate making, do you know whether the cost of transmission are allocated based on peak loads or average loads?
As far as rate making goes, I'm probably not the right person to ask on rate making how that will be handled.
Yeah, I'll ask Mr. Carrasco, and thank you very much. And again, I'm sorry for bringing you here for just a few minutes.
That's right. Thank you very much.
Take care.
Okay, and an additional 10 minutes was requested by NEE. So go ahead, Mariel.
Thank you so much. Good afternoon, Mr. Hawkins.
Good afternoon.
You referred just now to a system impact study that EPE or studies that EPE has done regarding the impact of the proposed community solar facilities.
Yes, as I understand it, and I listened to earlier testimony, that may or may not be the same as the hosted capacity question that you were asking, but my understanding is based on the community solar projects in the queue, there is a system impact study done each project at a time sequentially, but not all at once.
And so is it correct that there are 6 different community solar projects within EPE territory?
That's my understanding. I couldn't tell you the names and locations of all 6 projects, but that is my understanding.
Is the system impact study part of this record?
Not to my knowledge.
So then you were talking also separately about a hosting capacity analysis, also known as an integration capacity analysis, separate from the system impact study.
I'm not familiar with those terms. I'm only familiar with the system impact studies from our engineers is their participation on the transmission side.
And so there has not been some kind of integration capacity analysis done by El Paso Electric?
So if you could explain what you mean by integration, I know from a resource planning perspective and the capability of what amount of energy that will contribute over or peak, that is conducted by our resource planning area.
And is that in the record?
It's not one of my exhibits, so I'm not sure if it's in the record or not.
What about a study that demonstrates to the commission the cumulative capacity across all of El Paso Electric's distribution feeders?
I'm not familiar. The distribution design is outside of my purview. I'm not saying it doesn't exist. I'm just not familiar with whether it's part of the record here or not.
Would the system impact study or the integration capacity analysis help the commission understand whether community solar projects will actually use the utilities transmission system?
Well, to me, and I'm not understanding your where you're coming from in terms of use of the transmission system. I think from one standpoint, somebody looks at the flow of electrons and says that's the use of the transmission system. But the transmission system is much more than that. It provides voltage support and stability, even to distribution customers, right? And so, yes, those customers, whether they're taking community solar or they have rooftop solar, do benefit from the transmission system.
But you know that the rules say that the community solar we're talking about right now are to be connected via the distribution system.
That's my understanding.
Do you know if any of the community solar projects have actually been interconnected to EPE's system?
My understanding is they have not to this point.
And do you have an idea about what has caused the interconnection timeline delay?
My understanding is it's supply chain issues, and I think there's also one project that requires some distribution line, either reconductoring or new distribution to be done there. And that supply chain issues are things we've seen on the wholesale level for larger projects as well. We've seen those at other substation projects that we have. Have occurred in the last couple of years.
And were the community solar projects recently informed that the interconnection timeline delay would be for approximately 20 months or more?
I have an understanding, I'm not sure how recent that was, but I have an understanding that they were notified of delay.
And is the 20 months or more the correct is that the correct amount of time that EPE communicated to the different solar developers?
I don't have firsthand knowledge of the exact time frame.
And so because of those interconnection timeline delays, the solar projects have been unable to reach the construction stage. Is that right?
That may contribute to it. That may be the sole reason. They may have issues on supply chain on their own end as well. I'm not sure.
No further questions. Thank you.
Okay, thank you. Ms. Burns, any redirect?
No redirect.
Okay. That concludes the testimony for this witness. Thank you.
Thank you.
Thank you. We will change attorneys now also.
Thank you, Ms. Burns. Okay, Mr. Goldberg, let's proceed.
Thank you, Mr. Hearing Examiner. We're ready now. EPE calls Manuel Carrasco.
Mr. Carrasco, would you raise your right hand for me, sir? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon, Mr. Carrasco.
Good afternoon.
Put your full name and spell your last name for the record.
My name is Manuel Carrasco, Carrasco.
And what is your current profession?
I'm the manager of the rate research department.
Do you have before you a document that was previously marked EPE Exhibit 6?
Yes.
Do you recognize that document?
Yes, that's my phase 2 direct testimony filed in this case September 18, 2023.
And was your direct testimony drafted by you or under your supervision?
Yes.
Do you have any changes to that testimony?
I have a couple of corrections.
Will you please walk us through those corrections?
Yes, on page 4, there's a footnote. And what I need to do, I need to add the letter B between the 7 and the 8.
Are there any other changes?
Yes. On page, let's see, page 12, I need to do the same thing. Add the letter B between the 7 and the 8.
And it seems like you have one more change on page 17.
Yes, on page 17, I would like to strike the last sentence starting on line 13 and ending in line 14, along with the footnote.
That's footnote number 7.
Footnote number 7, correct.
And Mr. Hearing Examiner, we referenced this earlier. The 2 additional changes after the testimony was uploaded to Dropbox were the modifications to the footnote on page 4 and the last change on page 17 where lines 13 and 14 in footnote 7 were marked through. And would you like us to upload a corrected version with these changes?
Yeah, you can do that after today's proceeding.
Thank you. And Mr. Carrasco, is your direct testimony true and accurate to the best of your knowledge and belief?
Yes.
If you were asked the questions in that direct testimony today, would you give the same answers under oath?
Yes.
Mr. Hearing Examiner, we'd like to offer EPE Exhibit number 6 and accompanying exhibits for admission, and it will be uploaded in Dropbox as corrected EPE Exhibit number 6.
Okay, request is for EPE Exhibit number 6 and accompanying exhibits as corrected to be admitted onto the record. Any objection? Hearing none, they are admitted.
Mr. Carrasco, do you have before you a document previously marked EPE Exhibit number 7?
Yes,
Do you recognize that document?
I do.
Is that your rebuttal testimony that was pre-filed in phase 2 in this proceeding?
Yes, filed December 8th, 2023.
And was that rebuttal testimony drafted by you or under your supervision?
Yes.
Do you have any changes to the rebuttal testimony?
No.
Is the rebuttal testimony true and accurate to the best of your information and belief?
Yes.
If you were asked the questions in your rebuttal testimony today, would you give the same answers under oath?
Yes.
Mr. Hearing Examiner, we'd like to offer EPE Exhibit number 7 and accompanying exhibits for admission.
Request is for EPE Exhibit number 7 with accompanying exhibits to be admitted onto the record. Any objection? Hearing none, they are admitted.
Thank you, Mr. Hearing Examiner. We'd like to tender Mr. Carrasco for cross-examination.
Okay. I have 4 parties that requested cross-examination time. We'll begin with CCSA.
Thank you, Mr. Hearing Examiner. And before I get started, I know that I'm going to want to screen share, so I just want to check and make sure that that function is enabled.
You are now co-host and have screen sharing ability.
Great, thank you so much. Okay, good afternoon, Mr. Carrasco. My name is Elisa Greenwald, and I'm representing CCSA in this proceeding.
Hello, Ms. Greenwald.
It's nice to meet you. I'd like to talk to you today about EPE's administrative cost proposal. So let's go ahead and flip to page 15 of your direct testimony, and I'm going to be looking at lines 6 through 11. So I'll give you a minute to get there. Okay,
Page 15.
Okay, so you were asked whether EPE has calculated the cost for administering the community solar program. Is that right?
That's right.
Okay. And your answer to that question was no. Is that correct?
Correct.
Okay. And EPE's proposal is to charge subscribers and subscriber organizations certain amounts for services in the interim until the actual costs for administering the program are known. Is that right?
That's correct.
Okay. I want to turn to your rebuttal now at page 6, lines 8 through 15.
I'm on page 6.
Okay, great. You state that you do not believe it's necessary currently for EPE to develop complete estimates of both one-time and recurring administrative costs. Is that correct?
Correct.
Okay. And you explain that for a future filing or reconciliation, EPE intends to evaluate all of the charges and rates in its administrative cost rider based on the actual activities and costs over the course of 12 months. Is that right?
Correct.
Okay. You have not provided any testimony in this proceeding about EPE's expected cost for labor associated with the community solar program. Is that right?
That's right.
And you've also not provided any testimony about the costs that EPE might incur for technology system upgrades or modifications. Is that correct?
That's correct.
Okay. And you've not provided any ballpark estimate of the total administrative costs that EPE expects to incur, either upfront or recurring. Is that right?
That's right.
Now, because EPE has not calculated any estimates for the administrative costs it will incur to administer the program, when the company evaluates its actual costs after a year, they might vary from the current interim fees. Would you agree?
Possible. Yes.
And today, you can't say for certain how much the actual costs may vary from those current interim fees. Is that right?
That's right.
Okay. EPE does expect to recover the actual cost at some point. Is that right?
Correct.
And these costs would be recovered from subscribers?
Yes.
Now, would you
Or-
agree? Oh, go ahead.
All right. Or from subscriber organizations, depends on what the activity is.
Yes, okay, thank you for the clarification, that's helpful. Now, would you agree with me that subscribers value their subscription based on the cost and benefits of participating in community solar?
I would think so.
Okay. And the major benefit, at least if we're talking in financial terms, would be the bill credit that they receive. Would you agree?
Yes.
And then any costs would be the fees that they're charged from participating in the program, right?
Right.
Okay, so the value of a community solar subscription is basically the bill credit minus any cost recovered from subscribers, at least if we're talking in financial terms, right?
Restate that question, please.
Sure. Okay, so the value of a community solar subscription is the bill credit minus any costs recovered from subscribers. Would you agree?
Yes.
Okay. So along these same lines, additional cost that subscribers incur might reduce the value of their subscription, right?
Yes.
Okay. But without having forecasted actual administrative costs, EPE's subscribers don't currently know what monetary value their subscription will be after EPE seeks recovery of its actual cost. Would you agree?
They will know if we are approved the fees that we are proposing. They'll know those fees.
Yes, definitely. But I'm asking about the actual cost after you reevaluate those after a year. Would you like me to restate the question?
Sure.
Okay. So without having forecasted those administrative costs, EPE's subscribers don't currently know what the monetary value of their subscription will be after EPE seeks recovery of its actual cost, right?
Right. Yes.
Okay. Is it EPE's position that customers should expect that there will be unknown costs that pop up associated with their subscription?
Yes.
Okay, thank you, Mr. Carrasco. Let's switch gears a little bit and let's talk about some of the proposed administrative fees more specifically. So I'm looking at your rebuttal at page 3, lines 8 through 13. And here you're discussing EPE's proposed non-compliant billing data charge. Do you see that?
Yes.
Okay. To be clear, the non-compliant billing data charge will be assessed to subscriber organizations, right?
Correct.
Okay. And this is the only one of EPE's proposed administrative fees that is at cost rather than a set price. Is that right?
That's right.
Okay, I'm going to go ahead and share my screen. Okay, can everyone see this?
It is visible, yes.
Seeing nods. Okay, great. Give me just a moment. Okay, this is CCSA's interrogatory 4-1, which has been marked as CCSA Exhibit 8. You prepared and sponsored this response, is that right? And I can scroll down so that you can see that.
Yes.
Okay. Is this exhibit an accurate reflection of the response that you prepared?
Can I?
You want to see the stage too? Yeah, sure thing.
Okay. And what was your question?
Does this look accurate based on the response you prepared? Everything looks right?
Yes.
Okay, great. Okay, so I'm going to scroll to page 2. And in response to section C, you explain that EPE will not be establishing any protocols for subscriber organizations to fix the non-compliant billing data without incurring additional costs. Am I reading that right?
Right.
Okay, and this is because EPE claims that these protocols would be administratively inefficient. Is that right?
Right.
Okay, and EPE didn't attempt to develop any of these protocols, is that right?
Correct.
Okay. Mr. Hearing Examiner, at this time, I move to admit CCSA Exhibit 8 into the record.
Request is for CCA Exhibit 8 to be admitted. Any objection? Hearing none, it is admitted.
Okay, thank you. Mr. Carrasco, are you familiar with PNM's proposal for curing errors in billing data from subscriber organizations?
I'm not.
Okay, thank you. And before I wrap up, I'd like to briefly discuss one more exhibit. So I apologize, I'm going to share my screen one more time. Okay, and can everyone see that exhibit?
I can.
Okay, great. This is CCSA's interrogatory 7-5 that has been marked as CCSA Exhibit 9. You prepared and sponsored this response, is that right? And I'll scroll down again for you.
Yes, I did.
Okay, and is this exhibit an accurate reflection of the response that you prepared?
Yes.
Okay, this is a clarification point that I'd like to have on the record, but I don't have any substantive questions for you about it. So at this time, I move to admit CCSA Exhibit 9 into the record.
Request is for CCA Exhibit 9 to be admitted. Any objection? Hearing none, it is admitted.
Okay, and thank you so much for your time, Mr. Carrasco. I have no further questions.
Have a great day.
Oh, you too. Thank you.
The next party that requested time with Mr. Carrasco is City of Las Cruces.
Whoops, excuse me. Sorry about that. Things just fell off my desk. Good afternoon, Mr. Carrasco. How are you today?
Hello, Ms. Stevens. I'm doing fine. Hope you are too.
Good to see you. I think you've managed to find some people to delegate in a couple of recent cases. Haven't we not seen you in every case?
Yes.
Yeah.
Wonderful.
Yeah. Okay. I do have one question before we get into the substantive stuff about your changes. It's your direct testimony at page 17. Where you struck the sentence that begins on line 13. Why did you make that correction? Why did you make that change?
Yeah, that sentence is not relevant, given that the SOA that was approved in the settlement of phase 1.
Not relevant because of the SOA?
Because of the stipulated or the settled SOA.
Okay, so it refers to the proposed, not the stipulated. Is that what we're talking about? I think I understand. Okay, so I'd like to start where I left off with Mr. Schiestel. And that would be page 14, lines 4 to 12. And this is about the regulatory asset regarding solar bill credits, correct?
Yes, I'm there.
And the question is, that you has put to yourself is EPE requesting authorization in this proceeding to recover the amounts to be recorded to the regulatory asset if approved? And your answer is no. EPE is merely requesting an authorization to track costs. EPE will request approval for cost recovery in a future rate proceeding. which will provide opportunity for reasonableness determination of the recorded cost and a mechanism for authorized cost recovery. Because the regulatory asset is simply a cost tracking tool, if approved, it will not impact customer rates at this time. First of all, we'll going over some familiar ground now if you're listening to Mr. Sheetstal. The costs that you're referring to there that will be tracked are basically foregone revenues resulting from the solar bill credit with some adjustments. Is that right?
That is right.
And in that answer, you state that there will be an opportunity for reasonableness determination of the recorded cost. In your opinion, what would that reasonableness determination entail?
To make sure that what was recorded is correctly reflective of those non-recovery of costs that is embedded in the base rates. That was a part of the solar credit rate.
And what basis would the commission have for disallowing recovery of some or all of the costs that you put into that report in that regulatory asset? I should say bases in the plural, but what would be the grounds for disallowance in your mind?
That whether the commission believes that there's amounts that should be subsidized.
I'm sorry, could you explain that?
Yes, the Community Solar Act states that any cost attributable to community solar program should not be subsidized by non-subscribers. But then it also provides that there could be a 3% cap on there. So that's what I'm referring to, what amount of subsidization that's of those costs that are in this account are not going to be eligible for recovery.
Eligible for recovery from anybody or eligible for recovery from the subscribers?
Well, the recovery is going to be from either or, right? But the 3% cap is that recovery has to be from non-subscribers.
So your position is that, is it your position then, you said the recovery has to be from either or, is it your position that the regulatory asset request in this case guarantees EPE recovery of the difference, the amounts that it records in that regulatory asset, and the only decisions to be made by the commission have to do with allocating cost responsibility between subscribers and non-subscribers?
Well, like I stated earlier, the Community Solar Act does say that there can be no subsidization from non-subscribers. So, but there's that 3% cap. So and of course the commission can decide as they will, what amount is really a recoverable amount. But the basis here is that the Community Solar Act does provide for the limiting of subsidization by non-participants.
What about transmission-related costs, Mr. Carrasco? Your breakdown of the avoided costs addresses transmission-related costs, right?
Repeat your question.
The way that you've proposed your little bar chart, and I don't have the page citation right now. Transmission-related costs are one of the costs that you consider to be an unavoidable cost. Is that right?
That's correct.
And what if the Supreme, and you understand that the rule is, the Rule 573 is on appeal at the Supreme Court?
That's my understanding.
And that one of the issues on that appeal is the treatment of transmission costs, correct?
And my understanding is the treatment of transmission costs in the community solar credit.
Is that issue in the Supreme Court, correct?
I'm sorry, I didn't understand what you asked.
Is the treatment of transmission-related cost one of the issues that the Supreme Court ultimately is going to determine?
I'm sorry, I'm having a difficult time. Also, would you repeat the question? Your voice is dropping.
Oh, I'm sorry. Oh, I'm sorry. I did it again. I put my notes on top of my computer. Is that better?
Yes.
Yeah.
Thank you.
This with a really hard piece of cardboard is deadly. So sorry. I think I might be able to get away with one piece of paper. So if the Supreme Court is going to deal with the transmission issue, is that right? In your understanding?
That is my understanding.
But you've included the transmission costs in what you would be the transmission costs are reflected in what you're recording as something that maybe will be recoverable in the future. Is that right?
Correct.
So if the Supreme Court rules against the company and the other IOUs on that point, is that one of the costs that the commission would be able to disallow despite the fact that you've put it into the regulatory asset?
Well, I don't fully understand what the appeal is all about. I know that I think it's in reference to whether those transmission costs are included in the bill credit rate. But that's the intent, the extent of my understanding, whether those amounts should be included in that credit rate.
Okay, that's fair enough. I'm not familiar with what's in the appeal either, and I'm representing a party there. So let's move on to something else. EP is not proposing to track the actual costs of serving community solar subscribers, for example, as if they constituted a separate jurisdiction or rate class, is it?
Can you restate that question, please?
Okay, yeah, when you prepare your next cost of service study, because I know this is your roundhouse, the company isn't going to take is the company planning to take each of its existing rate classes, and for the ones that contain community solar customers, are they going to further break down the cost allocation so that a community solar, where'd he go? Where'd he go? Oh, there you are. So that a community solar customer, the community solar customers as a group will be separate from ordinary ratepayers, non-subscribers in the same rate class, whether it's residential, small commercial, what have you.
I believe we are not going to propose a community solar rate class. Those details have not really been discussed at this point.
And is EPE, I mean, I know you're the one who prepares, does the rate cases. So is EPE planning in any way to identify cost savings associated with having that 30 megawatts of additional solar generation added to its system at no cost to customers?
Similarly, we really have not talked about that, whether it's something that we should be identifying in our cost of service studies.
And just the way the cost of service study is done, if that capacity is there, if that, I wouldn't use capacity, if those resources, because they're energy and capacity resources, if they're there and there's no direct cost to EPE, right? Because they're owned by somebody else and maintained by somebody else. Will that result potentially in a subsidy from community solar subscriber organizations and community solar subscribers to other non-subscribing customers?
That's too much of a hypothetical. I really do not know. I haven't thought that far ahead. I'm sorry.
Okay. And does EPE have any plans to identify how the potential cost to serve new or increased loads in New Mexico since the last rate case and the current rate, and the current rates may have been decreased or offset by the addition of community solar facilities?
In our rate case, we'll be using historical data, whether that historical data reflects savings in there or on the opposite side, increases in costs. It'll be within those numbers.
And this may not be a question for you, but maybe it is. I'm not quite sure what your portfolio includes, but in between rate cases, which is where we are now, and hopefully it's where we will be when at least the community solar projects interconnect, is there a possibility that having this additional community solar energy coming on during the afternoons and during the daytime hours, that might reduce the costs for cost allocations for conventional generation for the say the residential class, if we assume that much of the community solar will be residential?
Objection.
Mr. Goldberg?
Just a compound question.
Anastasia, can you
I'll try, but
Yes,
may I ask I think Mr. Carrasco is hanging with me because he knows this stuff, but may I ask him whether he can answer it before I repeat it?
I'm sorry, Anastasia, you're gonna have to repeat it.
Okay.
That answers that.
That answers okay. So Mr. Carrasco, when we get to the next rate case, and let's start with the basic assumption here that we're talking about the residential class, and you've already testified that the EP doesn't have a current plan to break the residential class into subscribers and non-subscribers. So let's look at the residential class as a whole. If the residential class in the next rate case has reduced reduced peak demand because they've got a good chunk of this 30 megawatts of community solar attributed to them, will that alter cost allocations across the board within your cost of service study?
I think that in our next cost of service, when we're doing our analysis, we are gonna be looking at the loads of our customers, whether or not they're subscribers. And that is gonna be dictating how our cost allocation takes place.
So you're not anticipating at this point making any adjustments for the community solar that the subscribers are contributing?
As I mentioned earlier, I really haven't thought this far ahead. But right now, I don't think there is going to be a need to make such adjustment.
All right, that's interesting. Now I'm going to get back to a question that Mr. Hawkins deferred to you. So going to specifically considering transmission-related costs specifically, is it correct that in general rate cases, EPE allocates transmission-related costs among the rate classes based on a 4CP methodology?
I think the majority of the transmission function costs is 4CP. I think the dispatch is a 12CP allocation.
And 4CP means that you look at each class's relative demand on the highest peak hour of each of the months of June, July, August, September, right? That's meaning of 4CP?
Correct.
So if community solar were treated as a standalone rate case, or if you did sever out the community solar by rate customers by rate class, wouldn't that group, that entity, show a much lower or even negative use of transmission during those 4 peak hours of the year?
Like I mentioned earlier, I have not thought it that far into the future yet. But I think that we would not take into consideration the community solar contribution in our cost allocation.
Do you think that maybe you should, if the global issue here is what is a subsidy and what is not a subsidy?
We'll take a look at it.
But right now your regulatory asset proposal doesn't take this into consideration, does it?
No, it does not.
And moving on to something entirely different, which I'm sure you'll be happy to do. The $1 per month.
Stephen, sorry to interrupt you. Just to let you know, you're at your time limit. How many more questions do you have?
Two on one topic.
Okay, quickly, please.
Okay. The $1 per month per subscriber, sort of the head count charge that you're proposing, how much revenue does EPE anticipate obtaining annually through that fee?
It'll depend on how many subscribers there are.
Do you have an estimate or guesstimate?
I think I read that each facility has to have 10 customers. And there's 5 megawatts per facility, up to 30 megawatts total. So.
And are you familiar with the provisions of the act that call for a certain percentage to be allocated in shares of 25 kilowatts or less?
Yeah, so
it's more than 10 customers. It's going to be more than 10 customers.
More than 10 customers.
Okay. But you have not made an estimate or even a guesstimate of what kind of revenue that $1 fee is going to bring in.
No, we have not made that estimate.
And you haven't, I think you already answered the question that you haven't estimated the labor costs or the capital cost associated, the incremental labor or capital cost associated with dealing with treating certain customers as subscribers. Is that right?
That's correct. We have not made that estimate.
Thanks very much. It's good to see you again.
Good to see you too. Take care.
Okay, next on cross-examination is NEE, Mariel.
Thank you. Good afternoon.
Good afternoon.
Let me just pull up my document. Give me 1 second, please. Is it EPE's position that transmission costs are fixed?
In the short term, yes.
What do you mean by short term?
For example, the transmission costs that are in our cost of service, the cost of service right now is fixed. It's not gonna change if there's more energy consumption or less.
And so for how long does that fixed transmission cost last?
I would say, just looking at our depreciation expense, whatever number of years that that plant is depreciated over.
And it will change in the next rate case, won't it? Those transmission costs?
If there's been investment in transmission facilities, then yes.
And also if the depreciation of a specific resource is final, that would also affect it, right?
Depreciation expense, which is tied to those facilities, will likely go up if those costs have gone up.
Or could go down, right?
Or could go down, yes.
Because the depreciation schedule is over for some resources, correct?
Yeah, yes.
Is it EPE's position that transmission costs are unavoidable?
It is our position in this for this filing that they are unavoidable from the costs that are in our cost of service at this point in time.
Is it EPE's position that distribution costs are fixed and unavoidable as well?
Yes.
Could you turn to EPE Exhibit 6, which is your direct testimony, please?
Okay.
And could you go to page 13? Specifically, line 19. And here,
I'm there.
You say here, the CSA mandates that the qualifying utility and its non-subscribing customers shall not subsidize the costs attributable to the subscribers. Do you see that?
That's my testimony, yes.
But that's not accurate, is it?
I think it is.
Well, doesn't the law specifically allow for cross-subsidization if the commission determines that it is in the public interest?
Objection.
Mr. Goldberg.
Calls for a legal interpretation or conclusion.
Mr. Nanasi, your response?
It's in his testimony. I think I can ask him about it.
Yeah, to the extent that it calls for legal analysis, I agree with the objection to the point that we are referring to a specific part of testimony that may be non-compatible with that statement. I agree. So you could ask him in his opinion, but if that is compliant with this, with the actual language of it. However, obviously, I'm not noting that as a legal conclusion.
So in your opinion, doesn't the law specifically allow for cross-subsidization if the commission determines that it is in the public interest?
I recall reading that in the Community Solar Act.
So that means that that testimony there is inaccurate.
I don't think it is. We probably should bring up the law or what I reference here from the Community Solar Act and see how it reads.
Is it true that EPE will propose to collect in its next rate case what it deems fixed transmission costs from community solar subscribers in what EPE is calling a recovery charge?
It is our intent to request recovery of those revenues which were intended to recover such type of costs.
Specifically from transmission costs, right?
Including the recovery of transmission costs.
EPE is requesting authorization in this case to establish a regulatory asset to track transmission costs for recovery at a later date, correct?
No.
What are all the charges EPE expects to extract from community solar developers?
Restate that question, please.
Could you tell us all the charges that EPE expects to extract from community solar developers?
I do not know. There's and I first of all, the word extract kind of throws me off. I don't know what you mean by that.
Okay,
but
let me ask it a different way. What are all the charges EPE expects to charge community solar developers?
there's going to be like the metering charge that is listed in the administrative cost writer. Another one is if that non-compliant filling a data charge, if the data doesn't come in on time and accurately. There is going to be like house power. We are going to be connecting a billable meter for any power that the facility, the community solar facility, requires. I don't know if there's any interconnection charges. Just off the top of my head, those are the ones I can think of.
Did you just say house power?
I think that we do have, I think that the agreement, service subscriber organization agreement, allows us to provide power to the facility. I think I really didn't deal with the subscriber organization agreement, but I think it's listed on there. We can take a look at it if you'd like.
You did not rebut Mr. Farrell's testimony in El Paso exhibit number 7, did you?
Mr. Farrell? I do not believe so.
Did you see the EPE system impact analysis for the community solar projects?
No.
I have no further questions. Thank you.
Have a great day.
You too.
Thank you. Next for cross-examination, I have staff, Mr. Black.
Thank you, hearing examiner. Good afternoon, Mr. Carrasco. How are you?
I'm doing good. Thank you.
You're welcome. Let's see. I am going to refer to EPE Exhibit 6.
Okay.
I'm going to the question starting on page 5, line 12. Let me get there.
I'm there.
Page 5, line 12, and it starts. Question: How did EPE calculate its community solar bill credit rates? And then the answer, correct. And then your answer proceeds to say Rule 573, and then it says 17.9.573.20 NMAC provides detailed instruction on how the bill credit rate should be calculated. This is what I want to focus on now. Through a series of workshops, which were attended by commission staff and the qualifying utilities, a standardized methodology based on that instruction was developed, and EPE has followed this methodology in the calculation. Did I represent that correctly?
Yes, that's my testimony.
Okay. Now, beginning. Oh, all right. To your knowledge, has EPE or the other qualifying utilities been instructed to deviate from the methodology devised in those workshops for calculating the community solar bill credit rate?
Not to my knowledge.
Okay, thanks. All right, now I'm going to jump to refer to page 10 of that same EPE exhibit number 6, which is your phase 2 direct testimony. Number 10. And beginning at line 9, it's a section in your testimony about EPE's proposed revised rate number 47. Do you see that?
Yes, I do.
Okay. So you've attached to your to that exhibit the rate number 47. I think it's attached to your testimony as MC-2.
Yes,
Okay. And MC-2 represents rate 47, which was previously approved by the commission.
yes,
Okay. And then then on page 10, lines 21, moving over to page 11 to line 2, you indicate that EPE has filed an update of first revised rate number 47, which is represented by the exhibit attached to that testimony as MC-3. Is that correct?
that is correct.
Okay. All right, here's your question.
Okay.
Does EPE believe its updated rate is also consistent with the methodology devised in the workshops?
Yes,
Right. That's all I have.
thank you.
Thank you.
Yeah, thank you, Mr. Black. Mr. Goldberg, any redirect?
No redirect, Mr. Hearing Examiner, and EPE has no more witnesses and rests its case.
Okay, thank you. The witness is dismissed.
Thank you. Have a great day, everybody.
And our final witness for today's schedule is P&M and Mr. Babe. John, is Mr. Babe available, or do we need a minute?
If I could suggest to Mr. Hearing Examiner, if we've been going an hour and a half, if we could take a break, that would give Mr. Babe time to get set up in the witness room. Is this a good time?
Yeah, this is fine. Why don't we take a break for until 2:35.
Excellent, thank you.
All right, thank you. We're off record.
Hearing examiner?
Yes, Anastasia.
I just was wondering, I see other, now that EP is done, I see other attorneys and parties have gone black, no video, even though they're still here. I don't know what the protocol for that is, but I would appreciate the opportunity to, now that EP is done, go in and out of this hearing.
Yeah,
that
if you want to go black, by all means, go
I can
black.
go black. I can go black. It sounds
The only question, the only statement I'll make is, if you do intend to ask a question, please turn your video back on at that time.
Of course. Thank you very much.
You're welcome. Allison, are you all ready to begin?
Yes, sir.
All right, let's go back on the record. PNM, go ahead and introduce your first witness.
Thank you, hearing examiner. PNM calls Alaric Babé. Mr. Babé, do you have in front of you what's
Excuse
been
me,
marked?
excuse me, I need to swear him in.
Oh, yes, sorry, thank you. Go
Sir,
ahead.
would you raise your right hand? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. Mr. Babé, do you have in front of you what's been marked as PNM Exhibit 1?
Yes, I do.
And that's your prepared direct testimony?
That's correct.
And was that prepared by you or under your direction?
Yes, it was.
Do you have any corrections to that testimony?
No, I do not.
Is that testimony true and accurate to the best of your knowledge?
Yes, it is.
If I asked you those same questions today, would your answers be the same?
Yes, they would.
PNM moves for admission of PNM Exhibit 1.
Okay, the request is for PNM Exhibit 1 to be added onto the record. Any objection? Hearing none, it is admitted.
Thank you. And Mr. Babé, do you have in front of you what's been marked as PNM Exhibit 2, which is your prepared rebuttal testimony?
Yes, I do.
Was PNM Exhibit 2 prepared by you or under your direction?
Yes, it was.
Any corrections to that testimony?
No.
Is that testimony true and accurate to the best of your knowledge?
Yes, it is.
If I asked you those same questions today, would your answers be the same?
Yes, they would.
PNM moves for the admission of PNM Exhibit 2.
The request is for PNM Exhibit 2 to be admitted onto the record. Any objection? Hearing none, it is admitted.
Thank you, hearing examiner. Mr. Babé is available for cross-examination.
Okay, I have 5 parties that requested cross-examination time. The first party is CCSA. So who is going to be handling CCSA?
I will be. Thank you, Mr. Hearing Examiner.
Okay, thank you, Ms. Greenwald. Please proceed.
Yes, and quickly before I do proceed, I'm going to want to share my screen again. So I just want to make sure that that's still enabled. Thank you.
You should have that capability now.
Fantastic. Thank you. Good afternoon, Mr. Babé. Am I pronouncing your name correctly? Just want to make sure.
You are. Thank you, Ms. Greenwald. Yes.
Definitely. It's nice to meet you. I'm representing CCSA in this proceeding. And I'd like to start off by discussing PNM's position on a determination that subsidization is in the public interest. So if you'll do me a favor and flip to page 12 of your rebuttal testimony.
I'm there.
Okay, great. At lines 4 through 6, you state that PNM supports the commission determination that the public interest is served by subsidization up to the 3% cap for this initial pilot phase. Is that right?
That's correct.
Okay, and following that, in lines 6 through 14, you state that the public interest finding must be balanced with a commitment from the commission that the utilities can fairly identify the cost and avoided cost associated with implementing community solar, right?
Yes, that's correct.
Okay. You would agree with me that it's in the commission's discretion to determine which costs and benefits should be attributed to the community solar program, would you?
Yes, I do believe it would be at the commission's discretion how to bucket both the costs and the benefits of the program.
Okay. And then a bit further down at lines 10 through 12, you state that this determination must also be balanced with a commission commitment that the utilities must be able to recover the cost associated with implementing community solar, right?
That's correct.
Okay. And you would agree with me that it's within the commission's discretion to determine which costs are recoverable from community solar subscribers, right?
Yes, that's correct.
Okay. And generally speaking, the commission must only allow recovery of costs that are just and reasonable, right?
That's my general understanding, yes.
Okay, thank you. All right, let's move on and discuss PNM's proposal regarding carryover amounts and subscription sizing. So PNM proposes to look at the total bills that have a carryover amount in 6 months out of a 12-month period. Does that sound right to you?
Yes, that's correct.
Okay, and you're aware that in Mr. Barnes's testimony, he points out that Colorado does not require this type of ongoing monitoring.
That's my recollection of his testimony, yes.
Okay, and I think if you turn to page 23 of your rebuttal, that's where this discussion is, might be helpful. So at lines 9 through 12, you state that while Mr. Barnes argues that Excel Colorado evaluates subscription sizing at the time of subscription, there's been no process built into Mexico's rules for the utilities to ensure that a subscription is sized correctly.
Excuse me, there was some other noise. I didn't catch your question. You state while Mr. Barnes argues that Excel Colorado evaluates subscription sizing of the.
Yep. Okay, I'll go on from there. At the time of subscription, there has been no process built into New Mexico's community solar rules for the utilities to ensure that a subscription is sized correctly. Am I characterizing your testimony right?
Yes, that is in my testimony.
Okay, let me go ahead and share my screen. Okay, can everyone see the exhibit on the screen?
It is visible.
Okay, great. This is CCSA's interrogatory 7-12, which has been marked as CCSA Exhibit 10. You prepared this response, is that right?
That's correct.
Okay, and let me scroll down, and I'm going to ask if this exhibit is an accurate reflection of the response that you've prepared.
That's correct, yes.
Okay, so let's take a look at Section A. And you stated that PNM's proposal to monitor carryover amounts is based on New Mexico statute section 62-16B-5A1, not on awareness of other programs, right?
That's correct.
Okay, all right, I'm going to change my screen. Okay, great. So now we're looking at section 62-16B-5A1, which you referenced in that previous discovery response, right?
Yes.
Okay. And that section says, a subscription shall be sized to supply no more than 100% of the subscriber's average annual electricity consumption, right?
Yes.
Okay, awesome. I'm going to change my screen one more time. Okay, now we're looking at the Colorado Community Solar Regulations, and I'm going to direct you to section 723-3-3878 here in section B. Okay, so section B states that each CSG subscription shall be sized to represent at least 1 kW AC of the CSG's nameplate rating and supply no more than 120% of the CSG subscriber's average annual electricity consumption at the premise which the subscription is attributed. Does that look right?
Objection, hearing examiner.
Basis of the objection?
Yes. No foundation has been laid by, I'm sorry, is it Ms. Greenwald? No foundation has been laid. She hasn't asked Mr. Babé if he's familiar with this regulation, if he's read it, if he's had time to review it. I think there needs to be some foundation laid before we start asking questions on this regulation.
Yeah, Ms. Greenwald, any response?
Sure, yes. Mr. Babé's testimony implies a difference between what Excel Colorado is able to do based on its rules versus what is present in protections in the New Mexico Community Solar Rules. My question to Mr. Babé will not require any background knowledge on the Colorado Community Solar Rules. I'm going to ask him to just take a look at the plain language right in front of him and to draw a conclusion based on that, consistent with what he's testified.
Hearing examiner, may I respond?
Yes, Mr. Rillier.
I mean, Mr. Babé's testimony was just responding directly to Mr. Barnes' testimony comparing Colorado to New Mexico. It wasn't that Mr. Babé did an independent assessment of the Colorado and New Mexico differences.
Okay, I'm gonna note noting your objection, and I'll give it the weight that it deserves. You know, in the correspondence of Mr. Babé's total testimony, but I'll allow Ms. Greenwald to continue with her line of questioning at this time.
Thank you.
Thank you, Mr. Hearing Examiner. And I only have one question based on this. So Mr. Babe, based on what we just reviewed, which was the New Mexico Community Solar Statute and what's right in front of you, which is the Colorado Community Solar Rules, you would agree that the relevant measure is average annual electricity consumption. Is that right?
I'm sorry, could you restate that the relevant measure? Maybe just clarify that for me.
Yeah, sure. So in both the Colorado Community Solar Statute that we reviewed, section 62-16B-5A1, it discusses the community solar subscribers' average annual electricity consumption, correct?
Yes, in the Community Solar Act for the state of New Mexico, yes.
Okay. And in the Colorado Community Solar Rules that are right in front of you, and that's section B that we just reviewed, it also references that 120% of the CSG subscribers' average annual electricity consumption. Is that right?
Yes, based on what I'm reading here, only in that section without prior knowledge of this, I do see that it's 120% of the annual average annual electricity consumption. I would note that my discovery response that you shared earlier did state I'm not basing any of my testimony on a review of other states' programs.
Yep. Okay. Thank you so much. All right. So I'm going to go ahead and flip back to that same discovery response and we'll move on. Okay. So we're back at interrogatory 7-12. In your response to section D, you state that for on-site solar owned by a third party, PNM does an initial check at the time of the application that the system is not sized to supply more than 120% of annual consumption, right?
That's correct.
And PNM does not monitor ongoing compliance for sizing of on-site solar systems, right?
That's correct. It's this initial check at the time of application.
Okay. So let's say hypothetically that a PNM customer installs rooftop solar that's sized to supply at 120% of their annual consumption. And then let's say later all of their bad children who left all the lights on and the fridge door open move away to college. In this scenario, it's now possible that their solar array is supplying more than 120% of their annual consumption. Is that right?
Yes, in that hypothetical scenario, I would agree with you. The kids don't quite understand energy efficiency.
Exactly. We need to do more education, but so in this hypothetical situation, PNM wouldn't require any kind of reporting on changes to usage like what I described. Is that right?
That's correct, not for the on-site solar, based on the statute cited in this response.
Okay, and PNM wouldn't require the customer to rip the panels off of their roof. Is that right?
That's correct.
Okay, and let's take a look at section D2 of your response to this interrogatory. You state that PNM does not have an estimate for the cost of monitoring subscription size for community solar subscribers. Is that right?
No, that's incorrect. Just to clarify my response here, I'm referring to, I believe the question was, and maybe I can sort of see it here at the top, how much does monitoring this cost? And I'm referring to the check of the on-site solar, 120% for third-party owned systems. We don't have an estimate for the cost of monitoring that part of the screening of the application.
Okay. Do you have an estimate of what it will cost to monitor the sizing of community solar subscriptions?
No, I do not have a cost estimate at this time.
Okay. Presumably that would result in some cost, right?
Possibly, yes.
Okay. And if it did, would those costs be administrative costs?
I would, yes, I would venture to say they would be part of the administrative costs of the program in looking at the bill credits.
Okay. And any such additional administrative costs that are added in would reduce the monetary value of a subscription. Is that right?
Yes, if this is an added cost that would be recovered through the rider.
Okay, great. And Mr. Hearing Examiner, I could actually use a little bit of help here. I don't remember if I've already asked to admit CCSA Exhibit 10 into the record or not.
You have not.
Okay. At this time, I'd like to offer CCSA Exhibit 10 into the record.
The request is for CCSA Exhibit 10 to be admitted onto the record. Any objection?
Objection.
It is admitted.
Okay, thank you. I'm going to go ahead and stop screen sharing. All right, so lastly, I'd like to discuss the value of additional solar in PNM's system. Okay, so in your rebuttal at page 8, lines 14 through 16, you state that PNM already has significant solar generation deployed in its service area. So the value of additional solar generation is diminished without paired storage. Is that right?
I believe that's a summation, yes.
Okay. And actually, I'm going to go ahead and share my screen again. Okay, can everyone see that?
It is visible.
Okay. This is CCSA Interrogatory 7-4, which has been marked as CCSA Exhibit 11. You prepared this response along with Mr. Gutierrez, Ms. Buck, and Mr. Settlage. Is that right?
That's correct.
Okay, and I'll scroll down so that you can see the response. Does that look accurate based on the response you prepared?
Yes, it does.
Okay, so looking at section B, you state that the addition of storage on PNM's system can increase the hosting capacity of solar on PNM's distribution system. Is that right?
To restate that to make sure I heard it right, that the addition of storage can increase the hosting capacity for solar, is that?
Yes, on PNM's distribution system. And I believe that's in section B, just confirming.
Yes, thank you.
All right, so in section C, you were asked to admit that the addition of load shaping technologies or programs that shift energy usage into peak solar production times can increase the value of standalone solar. Is that right? And here, there's the question.
Thank you. Yes, and can you scroll down to the section C there that we're referencing?
Yep, absolutely.
Yes, that's correct. Noting the clarifications there that some of these are future looking and that the generation resources and the needs for that will change over time. These are also very highly locational based.
Okay, well, just for the benefit of the record, let's go over what's in the response.
Yes.
Okay, so in your response to this question, you stated that to the extent that that standalone solar is located to dispatch electricity at the time and location it's useful, the value of solar can increase, subject to those clarifications you just mentioned.
That's correct.
Okay, so overall, you would agree with me that through the addition of storage and the use of load shaping technologies, PNM can manage its grid to maximize the value of additional solar, right?
I would agree that with, yeah, a lot again, and I'll offer some clarifications here. As long as the additional storage and we can say programs or load shaping technologies are at a similar location as to the solar, it would increase the hosting capacity for solar. That's correct.
Okay. At this time, I move for the admission of CCSA Exhibit 11.
Request is for CCA Exhibit 11 to be admitted onto the record. Any objection?
Objection.
It is admitted.
Okay, and I believe that's all I have. Thank you so much for your time, Mr. Babe. No further questions.
Thank you very much.
Okay, next for Mr. Babe is REIA, who requested 10 minutes.
Yes, thank you. Mr. Babe, before we get started, I just need you to pull up your direct testimony. And
Okay.
also, if you could go into the Dropbox and pull up Administrative Notice Exhibit 13, which is 6216B5 subscription requirements.
62. Is this the Westlaw 8 full text items? Are we looking at the same thing?
Yes, and you want to go to page 7 of 12 on that PDF, and you'll find that definition. Tell me when you've got all that, and we'll begin.
Okay, I am on page 7 of 12. A subscription shall be.
Okay, thank you. And all right, so I would like to start with your direct testimony, and I also would like to talk about the carryover amount and the subscription size, if that's okay with you.
Yes, those seem to be popular talking points today.
All right, good. So I just want to identify, you've raised a couple of issues. And the first one is whether in verifying subscription size, you ask on page 11, lines 20 and 21, whether it should be determined initially or if the utility should continue to verify subscription size.
That's correct. It's currently unknown. There's not direction as to if it should be done initially or over time.
And from reading your testimony, it appears PNM, while not directly answering that question, that you are advocating for an ongoing verification process, or would it be a one-time deal?
Our current proposal is an ongoing process as we are not involved in the initial subscription to community solar facilities.
Okay. What just happened? Are you there? I've just lost the Zoom screen. Can you hear me?
I can hear you.
Wow, that's really weird. I can't
Be
see it.
careful
Hold
what
on.
you say.
Yeah, right. Okay, I'm back. I'm sorry. It just bleeped out on my screen for a second. Apologize for that. All right. So you explained how, I think you discussed in your not in your testimony, in your cross-examination a minute ago, how you are aware that with the Colorado statute that was discussed with you, there was an initial verification and not an ongoing process, right? Well, let me.
Oh, go ahead.
I'm sorry. Let me just. That was part of my question. Are you also aware though with the DG on PNM's in PNM's DG program, that's also just an initial verification and not ongoing? I think that was your response to CCSA Exhibit 10, right?
Yes, just to clarify that I'm answering the correct question. For behind the meter distributed generation owned by a third party, so this would be common in like a PPA arrangement that a residential customer might sign into. There is an initial check for the system size at 120% of annual energy usage.
Is there any reason PNM hasn't elected to do something similar to that, and we've got this complicated process instead? Why can't we do it like PNM does DG is my question.
So currently, PNM is not involved in the subscription to community solar. There's not an application set up in the same way that it is for behind the meter solar. So for behind the meter solar, every new installation goes through an application process that goes through PNM's interconnection department for screening. And those that are owned by a third party must comply with that 120% rule. For community solar, there's not an interconnection application as such for each individual customer. That is a discussion between the subscriber organization and the potential subscriber, and PNM is not involved in that. So currently there is not an application for a customer to receive approval from the utility for subscribing, which is why we've proposed this check on the back end, as it were. We will be receiving the data file with the subscribers. And so it seemed most appropriate that that is when we would be applying the check to ensure compliance with statute.
Okay, well, understanding PNM's not involved in this application process and everything, isn't there a way for you to come up with a more simplified process so as PNM could simply verify the things it needs to verify to ensure that the subscription meets the requirements without, in other words, do it on the front end? Is that theoretically possible to do it that way?
Theoretically,
again, assuming you were provided the information you needed that you don't have.
Theoretically, I think it would be possible. I would offer some caution as to whether or not that would be simpler to require customers to go through a separate application process through the utility in order to subscribe. Of course, anything is possible. Our proposal here is based on our understanding of how the program will roll out and that the first time PNM will receive any data for who is subscribed is after the subscription has begun.
If you did that though, wouldn't it just, all right, let me just move on here. Looking at the definition under 6216B5, which you pulled up, the subscription shall be sized to supply no more than 100% of the subscriber's average annual electricity consumption. When we're talking about average annual electricity consumption, that's in kilowatt hours, right?
That's correct.
And we're talking about the subscription supplies no more than 100%. That supply is also in kilowatt hours, correct? It would be measured in kilowatt hours.
That's correct.
And if you look at the words annual electricity consumption, doesn't that mean how much they've consumed over 12 months?
Yes, that's correct.
And if you look, annual energy consumption is 12 months, but what is the average annual energy consumption? Does that mean something different? Like we look at their 12-month average for 3 years. So in other words, you're not just looking at a month, you may be looking at even more than a year when deciding what's average, right?
Objection. That's I think there's like 2 or 3 questions in there, maybe 3 or 4. Maybe if Ms. Sarah could just break it down.
I think let's start with his interpretation of what average means and move from there.
Thank you.
It would depend per customer. Some customers have not been at their at that residence or that location for more than a year, in which case that would be a year. For customers that have been there longer, it could be longer. But yes, there is not a based on the language in the statute. There is not a specific number of years that must be looked at.
PNM knows, has the information, doesn't it? In number 1, it would know, it would have information about the subscriber's average annual electricity consumption, right?
Yes, again, with the understanding that some customers have been at that location for longer or shorter.
Okay, and PNM is going to know how much in kilowatt hours a community solar facility is supplying to that customer through its subscription, right?
Not necessarily, no. We will receive through the data transfer process the monthly kilowatt hour subscription value.
You're not going to know how many kilowatt hours is allocated to that customer?
So my understanding of how community solar works, it's not known exactly how many kilowatt hours are going to be produced by any single facility. Subscribers will be subscribing to a portion of that facility based on capacity, most likely. So kilowatts. Based on.
Let me stop you. I think you understood my question wrong. I'm asking about how much is supplied after the fact. After the fact, not how much it's going to supply. So what I'm saying is the 2 things you need to know to find out if a subscription is producing more on an annual basis in kilowatt hours than the customer is consuming, you would be able to determine that from PNM's own database, your own billing system, your own records, right?
We will receive the monthly kilowatt hour subscription via the data transfer process. We will not have information forward-looking in any way about the total number of kilowatt hours that a customer will subscribe to.
I'm not asking, okay, I'm sorry, but I'm not asking how much they're subscribing to, because they're not subscribing to kilowatt hours. They're subscribing to a kilowatt of subscription. The question I'm asking you is the subscription is supplying kilowatt hours of energy, right? You know how much is supplied to that customer. That's what I'm asking. That's all I'm asking. In a year, when you're trying to determine if that customer has violated the limit on sizing, PNM knows how much that customer consumed and how many kilowatt hours of solar were generated that belong to that customer, right?
Hearing examiner, I'm just going to object. Mr. keeps interrupting Mr. Bay. I think he's trying to answer her question to how he understands it. She keeps interrupting, and then she's fired out about 4 different questions in the course of after interrupting him. So I'm not even sure what the question is on the table. And I think Mr. Babe is trying to explain his answer.
Yeah, Mr. Babe, do you need any further clarification?
If I may attempt to respond, first, I apologize if there's any confusion. We will only receive the monthly kilowatt hour subscription every month. If we go into the future, yes, we will be able to look back and see how many kilowatt hours we're subscribed to after the fact. And hopefully
Okay.
that's answering your question, but I'm happy to try again if you want to re-ask.
No, not really. I guess what I'm getting at is that you want to use the carryover amount. So if a subscriber has 6 months in which there's a carryover, you say that may indicate the subscription is sized to supply more than 100% of the subscriber's average annual electricity consumption. I guess what I'm getting at is, isn't that a more indirect way of making that determination than looking at how much they used in kilowatt hours and received in kilowatt hours, all of which you already have? That's all I'm asking here.
And to clarify, your proposal is to do that after 12 months only.
I'm asking a question.
Apologies. So yes, theoretically, we could look at that after 12 months. Our current proposal is to look at a carryover amount in 6 out of 12 months to ensure compliance with the statute. PNM witness Michael Settlage has some more details on how that calculation would work, but we think it's a very conservative way to make sure that we are complying with statute.
Okay. So then if there is a carryover amount, Mr. Hearing Examiner, I'd like to just take a second here. Can I add 5 minutes for Mr. Settlage? I feel like I'm going to go over.
Yeah,
I mean,
we are over your requested time. I mean, we're on schedule. So if you want, are you asking for a 5-minute break or 5 more minutes of cross-examination time?
Just 5 more minutes to continue.
That's fine, but then I will conclude. I will conclude in 5 minutes then.
Thank you.
So
Thank you,
don't
sir.
go over that one.
You'll have to let me know. I don't have a time.
I will.
Okay. All right. So your process is going to look at carryover amounts, which is a proxy for excessively sized subscriptions, right?
That's correct.
Okay. Now, you say that what happens if they go over is that PNM will report to the commission and provide a list of subscribers whose subscriptions exceeds the 6-month carryover. And then the subscription organization, here's what you say, and then let's see. The subscriber shall not be permitted any carryover amount until the subscriber organization informs PNM and the commission the subscription has been modified to conform with section 6216B5A, or the subscriber organization provides an explanation to PNM and the commission that the cause of the carryover amount is not a result of the violation. So my question to you, what explanation, documents, what would the subscriber organization need to provide PNM to prove there's not a violation?
I think it would be a simple written statement of possibly what could be happening. This could be any number of things. Before we were talking about kids moving out, there could be people moving in. There could be additional equipment that was installed in the house. It could be a purchase of an electric vehicle, for example, that had happened after the subscription or right at the time of subscription. So possibly PNM didn't have backward-looking data. So I think there are a lot of a lot of different explanations that could be acceptable, and that's why we would want to involve the commission as well in that determination.
So then what you're saying is they would have to explain why their usage is changing and it doesn't match the subscription anymore?
Why the subscription is not oversized is how I would frame that. Yeah, either the usage is changing or the subscription is sized correctly for reasons X, Y, and Z.
So the evidence you're suggesting that would show the statute is not being violated is that the usage is what, temporary, and that it's not really reflective of the average? Is that what you're saying? I'm just trying to understand, because when you just say they have to show it's not a violation, what evidence would show that? Okay, but I'm not going to ask you that again. Let me just ask another question then. You said the commission would have to decide. What would the process be for the commission deciding if that's acceptable evidence or not? Do we have to have a hearing for each of those subscribers to present that evidence?
I would hope we wouldn't have to go to hearing as much as we all enjoy these. I think that these could be informational filings. There's a number of different filings that go through the commission. I don't have an exact process laid out, but PNM's current proposal is that there is a filing that goes both to PNM and to the commission, so that all parties are informed of the number of possible oversubscriptions and reasons that they may or may not be right-sized.
So it sounds like you don't have any standards that the commission would apply to determine whether the rationale for using less electricity should justify allowing this status quo or requiring a modification. We don't have any standards to determine that?
I do not have standards proposed at this time, no.
Okay. And why can't PNM, as opposed to making the subscriber organization come in and justify every customer's usage that had this carryover, couldn't PNM at least screen those customers and say, hey, we've looked at your, what we talked about before, your average annual energy consumption. We compared that to your average kilowatt of energy supplied from community solar, and they're both 600 kilowatt hours. So even though you exceeded that 6-month carryover, you're not violating the statutory provision.
I believe that the question is, could we screen them internally and make sure after a year that those two amounts are equal? I think that is something that could happen, yes.
Okay, so if that's the case, then PNM doesn't necessarily have to report all the subscribers that have a carryover in 6 months or in 12 months. I mean, if you already know that, why do subscribers have to come in and explain to you what that's about? Why do the organizations have to do that if you can already figure it out on your own?
So the current proposal is 6 out of 12 months with, as I described, a very conservative amount, I believe. And I don't have the exact reference in my testimony, but I know PNM witness Michael Settlage does discuss this. It would be an oversubscription of about 140% on a given month. I would, however, tend to agree that if there is an average that is very clear over the course of the year, it is possible that an explanation is not necessary.
Okay. Well, thank you for answering my question, sir. That's all I have.
Okay. Thank you. Sorry for the misunderstanding.
No, I'm sorry for my long questions. I have a habit of doing that. I apologize.
No worries.
All right, next cross-examination is NEE. You have 25 minutes. There you are.
I believe you're muted.
Good afternoon. Sorry about
Afternoon. No worries.
that. Sir, would you please turn to P&M Exhibit 1, your direct testimony? And I want to turn your attention to page 11.
Okay.
Line 7.
Okay.
Could you please explain what a 12-month vintage means?
Yes, this would be the vintage of the generation. That is a sort of a timestamp, month and year.
And does that mean there's going to be a 12-month lag in payment after production?
Yes, if there is unsubscribed energy that has not been allocated within a 12-month period, P&M will buy it at rate 12. But it has to reach that 12-month period before.
And could you now please turn to page 16?
Yes.
Here you're talking about administrative costs. And my question to you, sir, is why will these community solar administrative costs be recovered in rate base rather than in the community solar administrative rider?
Can you point to me exactly which costs you want me to answer for?
You could tell us all about all of them. But I think it says here, as noted in the testimony of P&M witness Settlage, these capital costs associated with the community solar implementation will be recovered in base rates and not as part of the CS, Community Solar Administrative Rider. And just before that, you discuss what those costs are.
Okay, yes. Looking at page 16, I believe the costs that I refer to that would be recovered in base rates are the upgrades for the billing system. I note the design, development, programming, testing, and implementation of community solar in the billing system. That would be base rates. Other ongoing administrative costs would be in the rider.
And are there other costs relative to community solar that P&M is proposing will be in base rates other than what you just testified to?
I don't know offhand if I'm capturing all of the costs here. These are the main one-time costs that I believe we would incur for the upgrade of the billing system to allow for community solar.
Sir, do you know what a hosting capacity analysis, or otherwise known as an integration capacity analysis, is?
I'm familiar with hosting capacity, at least in the general sense.
What do you understand it to be?
So this would be an engineering exercise looking at different points of the system to understand how much, in this case, how much solar capacity could be interconnected at a given location.
Did P&M perform a hosting capacity analysis in this case to demonstrate to the commission what the cumulative capacity across all of P&M's distribution feeders could support?
Not to my knowledge, no.
Had P&M performed a hosting study, wouldn't it help prove or disprove whether community solar projects will use the utilities transmission system?
I really can't speak to that, to be honest, because I've never run a hosting capacity analysis myself, and I'm not certain what the outcomes of that would be.
Do you know if any of the witnesses, P&M's witnesses, would be a better person to ask about that?
Not for a hosting capacity analysis per se. We did have one witness, witness Cindy Buck from distribution planning, but I believe she was dismissed. But I don't know if she could answer that either, to be perfectly honest.
And nobody else from P&M who was testifying in this case could speak to that issue. Is that right? That you know of?
Not that I know of specifically, and in regards to performing a hosting capacity analysis of the entire system, I don't know of anyone who would speak to that with certainty, as that was not proposed to my knowledge.
I actually have nothing further. All the other questions that I was going to ask have been asked by others. Thank you.
Thank you.
Okay. Next person requesting time was NMPEC for half an hour.
Good afternoon, Mr. Hearing Examiner, and good afternoon, Mr. Babe.
Hey, Missy, how are you?
I'm good. Nice to see you. It's been a
You as
little while. I took a break, but I'm back.
Good.
Let's see. I'm gonna need a share screen also, Mr. Hearing Examiner.
Okay, give me 1 second.
And I was testing it earlier and I might have, I was assuming it was off and I might have thrown Stephanie's off because it suddenly popped up. But let's see if it works now. Okay. So again, let me get oriented here. And then I'll... Again, good afternoon, Mr. Babe, and as I said, it's nice to see you.
You as well.
I would like to ask you to look at your rebuttal testimony on page 11, starting right at the top.
Okay, I'm there.
And so I'd like to have you look at that testimony because there you're referring to a particular part of the Community Solar Act. It is NMSA 1978, section 62-16B-7B8. And I'll go ahead and read it to the hearing examiner. But I assume you have it there in front of you, your testimony, right?
I do.
Okay. So what you're saying, the question here is, what direction does the Community Solar Act provide regarding the subsidization of community solar subscribers by non-subscribers? And this is another popular point, but I'm gonna maybe look down a different path. That is to the statutory language. And here you're quoting from the statutory language, Mr. Babe. You're saying in your answer, NMSA 1978, section 62-16B-7B8 provides that, quote, non-subscribers shall not subsidize costs attributable to subscribers. But this prohibition has one caveat, period. Specifically, the commission may, and now here, quote, you're quoting here in your testimony from the statute, determine that it is in the public interest for non-subscribers to subsidize subscribers, but non-subscribers shall not be charged more than 3% of the non-subscribers' aggregate retail rate on an annual basis to subsidize subscribers, close quote. That's your testimony, correct?
That's correct.
Okay, so, and I know, I recognize that you already answered, some questions from, CCSA attorney, Ms. Alyssa Grunwald earlier, just about an hour ago, about, this, this, section of, the, Community Solar Act, CSA. About the 3% and about the public interest. And you go on to testify about what that means and the public interest as it relates to phase, to this pilot phase. That was your earlier testimony, right, Mr. Babet, in response to Ms. Greenwald's questions, correct?
Yes, that's my recollection, and I do believe it's also what's reflected here in P&M Exhibit 2.
All right, so what I have put up here on the share screen is a little bit more from this section of the CSA, from the Community Solar Act. Do you recognize it, Mr. Babet?
That looks like it's from the act to the best of my recollection.
Well, let me just see if I can refresh your memory. That 16B, I'm gonna scroll that down here. So Chapter 62 relates to public utilities. You remember that, right?
I would hesitate to say I'm an expert in exactly which laws apply. But I'm happy to read what's on the screen.
Okay, let's go back to the screen then. Do you remember that 16B is the Community Solar Act itself? So everything in the Community Solar Act is labeled 16B. Do you remember that?
Yeah, that I would seem to agree with that based on my quoting of the statute in my rebuttal testimony.
Okay, good. And you are a manager in charge of community solar, aren't you?
I do oversee the implementation of the community solar program, yes.
I want to be sure that you get all the credit that you're due for all the hard work that you have done for the Public Service Company of New Mexico, and I know that for a fact.
Thank you. I need to start remembering some of the numbering now, so thank you.
Okay, and then 7 is about the Public Regulation Commission's kind of involvement in the Community Solar Act. Does that sound right to you?
Yes, based on everything I'm seeing.
All right, so then here we are at 7 and this part that I've copied here. And so that section B, I did happen to copy this part, addresses the commission's obligations and duties with regard to the rules, right? So what it's saying is that the commission shall adopt rules to establish a community solar program by no later than April 1, 2022. And do you agree that this is verbatim language from the Community Solar Act?
Yes, this does appear to be from the act itself.
All right, so now we're hitting home because this is the next part that I'm going to show you is the section of the Community Solar Act that you quoted in your testimony, and that part of the testimony that we're discussing at this moment on page 11, starting at line 1, correct?
Yes.
And so what I'd like to do is read this section in its entirety. And I think, let me back up here. What I'd like to do here is locate your citation from the statute in your testimony on in this paragraph, which is toward the end. Provided further, and I'm putting my cursor here, provided further that if the commission determines that it is in the public interest for non-subscribers to subsidize subscribers, non-subscribers shall not be charged more than 3% of the non-subscribers' aggregate retail rate on an annual basis to subsidize subscribers. So that's the portion of subsection 7 that you quoted, right?
That's correct.
In your testimony, correct?
Yes.
On page 11.
Yes.
Okay, so I'm going to read the whole thing. And the whole of subsection 8. And I said 7. I think that the previous witness had the similar problems I'm having in citing the right numbers, but this is 62-16B-7 as
7
indicates. And that now we're going to scroll down to paragraph B of subsection 7, and B has the subsection 8. So subsection 8 in its entirety states, provide a community solar bill credit mechanisms for subscribers derived from the qualifying utility's total aggregate retail rate on a per customer basis. And now I'm going to look at my annotations. Less the commission approved distribution cost components. So that's the first part, that the commission has the duty of providing a bill credit rate mechanism that is based on the TAR, what we've been referring to as the TAR, less the distribution cost. So that's the first thing it has to do. The second thing, is that correct? Would you say that's a fair way of breaking down that section, Mr. Babay?
Based on my understanding of the statute, yes, I believe that that's all there.
Yes, and we're looking at it all together here, right?
Exactly. Yes.
Yeah, and then comma, and then the way I read it, Mr. Babay, the next part is to identify for PNM, or I'm sorry, for the PRC, to identify all proposed rules, fees, and charges. Correct? That's kind of a separate obligation from the first part, right? Are you with me, Mr. Babay?
Yes, I'm following you. I mean, it's definitely related to the first part as a clause of the sentence.
Yes, but it's a kind of a discrete duty or function or operation, right?
Okay, yes.
From the first part, which is providing the mechanism, and the second part is providing the justification. Would you say that's fair?
I'm just hearing examiner. I don't want to break up Ms. Dees, but I just want to clarify. There's a lot of interpretation of the statute going on here. I assume, Ms. Yee, you're not asking for a legal conclusion. You're asking for his expert testimony. But we seem to be parsing a statute like an attorney would. And I don't think that's what Mr. Babay's role here is.
Yeah, I think we're stepping into briefing territory, but Ms. Yee, can we get to the crux of this line of questioning for Mr. Babay?
Thank you, Mr. Hearing Examiner, and thank you, Debria Twilliger. It's easier to say Debria after you taught me how to say that. Debria Twilliger. No, for sure. And I'm sorry, I'm belaboring a little bit too much. And as a matter of fact, the crux of the problem, the crux of the issue, Mr. Hearing Examiner, is coming right up because it's highlighted. I highlighted this. This is my own emphasis. The next part of the statute says, provided that non-subscribers shall not subsidize costs attributable to subscribers. Am I reading that statute exactly the way it is written, Mr. Babay?
Yes.
Okay. And then I'm going to leave it. The rest of it we already discussed, because the last part of it is what Ms. Greenwald questioned you about. correct, Mr. Babe?
That's correct.
Thank you. And I see, whenever I see someone shaking his or her head, I always want to be sure that for the record, you agree.
Understood. It's hard to type out a nod in the court reporter, so
Yes, that's exactly. All right, so now I'm going to move on to some questions about costs. So my questions about costs have to do with this. The regulatory scheme, and I know you're not a lawyer, and I'm not going to ask you to recite the Public Utility Act, but as an experienced manager of a regulated entity who testifies regularly at the Public Regulation Commission, do you understand that the Public Utility Act dictates rates that public utilities are entitled to charge? Do you understand that?
My understanding of the Public Utility Act is not that the rates are set that would go through a rate case, is my understanding.
Yeah, and that's something that I wanted to ask you, if you understood that rates are determined in rate cases, and your answer is yes, right?
Yes, that's my general understanding.
And is your general understanding that the rates are determined by the Public Regulation Commission depending on the evidence that is presented by public utilities as to the costs that they have incurred in providing the electricity that they are certified under the law to provide in their jurisdiction? Is that right?
That's my general understanding, although I personally have never been part of a rate case.
Well, we're trying to understand what costs mean to not just to a regulatory lawyer, but to a regulatory manager, Mr. Pepe. So that based on that, would you say, would you agree with me that costs depend that the utilities have an obligation under the Public Utility Act to provide evidence to the Public Regulation Commission as to the costs that they have incurred? Is that fair to say, in a general sense, that you would have that understanding?
Yes, in a very general sense, without having been through a rate case myself, I know that a large part of the argument is the costs that have been incurred or possibly will be incurred to set rates.
Okay, so and then I'm going to ask one more, a little bit more technical, and then I'll draw back to maybe revisit some of the issues that we've already talked about with some of the other attorneys. But the question here is the costs that the public utilities prove up in a rate case depend on cost of service studies, right? Have you heard of that term, cost of service study?
I've heard of that term, but again, I have not personally been involved.
All right, so you've heard of the term, and have you heard that the cost of service studies involve the cost of generating electricity, right?
I would assume that would be a component of it, yes.
Transmission costs, right?
Based on a general understanding, yes.
And distribution costs.
Yes.
And administrative costs, right?
Yes.
But not loss of revenue, right?
Where?
What?
I'm not aware of what might be omitted from a cost of service study.
All right, I'll leave it there. I'd like to ask you questions now about the sizing, and we've covered that quite a bit.
Mm-hmm.
And but I just and this is my last set of questions. Am I over time already, Mr. Hearing Examiner?
No, I actually have you with 13 minutes left, so you're in good shape.
All right. So you've already discussed with some of your attorneys the issues related to sizing a subscription, and about the term average annual consumption. So my question is, do you agree that an average residential customer's electricity usage can vary significantly from year to year?
I would agree that actual energy consumption could vary year to year. The average would take that into account.
Could you explain that a little bit more? What's the difference?
So the question was if, as I understand it, was if average annual electricity could change significantly from year to year. My clarification is that actual energy consumption could vary from year to year, but an average inherently takes those into account by averaging the consumption data at hand.
Well, now I'm thinking we're playing with words, Mr. Babet. And so what you just said was that the actual consumption can vary, but not the average, but that would depend on whether you're doing an annual average or maybe a 5-year average, right? Those are going to be different, won't they? Those will be different.
I'm sorry for any confusion. I don't understand what an annual average would be. If you're only looking at 1 year, it's 1 year. If you're looking at 2 years, you would average between the 2 years.
Okay.
That's the clarification I'm trying to make.
Okay, thank you. All right, that's fair. So that when getting down to basics, when we're talking about the variations or the differences, and okay, so I'm sorry, let me think about this here. So I'm thinking about what you just said. So that for, like, let's take an hypothetical customer A, and this customer has one value that represents an annual average consumption for, say, 2021, right? That would be an annual average consumption of because that would be for that 1 year. Is that what you just testified? Is that what you meant to say?
So taking a hypothetical customer, what I mean to say is if I have all of the energy consumption for 1 year, the actual consumption, that's the 1 year of data. So that represents 1 year of data.
Okay. And so the 2-year average, how would you calculate that?
So if I had 2 years of data, for example, and I'm going to use numbers that I can do on the fly. So if in, let's say in 2022, a customer used 5,000 kilowatt hours, and in 2023, a customer used 6,000 kilowatt hours, an average annual consumption would be 5,500 kilowatt hours.
Between the 2 years, right? Based on
average between the two, yes.
So that the third year could be different because of the variables coming together in different ways, right?
That's correct.
So the variables would be the weather, correct?
Yes.
And changes in electrical loads, like adding an electric vehicle.
Correct.
And I think that you talked about this in your answers to other attorneys, correct? That that there can be projections made at this time about increased electrification. I know we were in the transportation electrification case together.
Yes, correct. Yeah. So hopefully there will be a lot of electric vehicles plugged in that would affect the load of a customer.
So there are going to be trends that cause customers to increase their electricity usage as on the whole, right? Is that right?
There could be. It is highly dependent on the customer themselves, what electrification measures they decide to participate in.
On the other hand, there are many, many trends in public policy that cause customers to reduce their usage, correct? Like energy efficiency programs. Am I right? Do you
That's
agree?
correct. We also offer a comprehensive energy efficiency portfolio to help customers reduce their load.
So there's a lot of emphasis in your testimony to addressing PNM's concern that subscriptions will be oversized, correct? Am I correct? I'm characterizing your testimony, but I read it very carefully. Is that true?
Yes, my testimony offers PNM's proposal to monitor the oversubscription that may occur with certain customers.
And so there is also there's also a good chance that customers will also be undersized. Is that correct?
That's correct. There are certain customers that will not subscribe to the full 100% of their average annual consumption.
For example, if they buy an electric car.
Yes, that's a possible example.
So does PNM have any recommendations as a manager of that section of PNM on the community solar program and other electrification programs? Not other, I should say, and other programs like transportation electrification. Do you, Mr. Babay, have any recommendations for alerting customers when their subscription is undersized?
No, because the statute does not provide any floor or minimum subscription size that a customer should have. That is up to them. The statute only has language for compliance that the subscription is not oversized.
Okay, Mr. Hearing Examiner, would you give me a minute while I look over my notes?
Absolutely.
Oh, I did have one other maybe two related questions. And
Hearing Examiner, may I ask Ms. Yee to take her, I don't think she's using the statute down, and just so I can see everyone easier, she can maybe
I'm
stop.
sorry, what did you say? Mr.
Missy, could you stop your screen sharing? I don't think it's
Oh,
necessary.
yeah. Oh, yeah, that's an
Okay,
excellent point.
Thank you.
All right. There we go. I'm so
Thank you.
sorry. I try to remember that to not do that. I think at one point in your testimony, it was in your direct testimony. You were saying that on page 7, you're on behalf of PNM, Mr. Babay, you're proposing that the program tariff, you're proposing that PRC approve that the kind of general principle that PNM would be allowed to update the program tariff with certain attachments without a hearing, but with notice, I think. So I wanted, and this is like a question maybe we should have asked in discovery. I don't really know the answer to this. What do you consider, Mr. Babet, a legitimate change to the tariff that could be updated in this way without a hearing? I know,
So,
or in the street light, just to give you like my parameters, my boundaries, in the street light tariff that I know a lot about because I used to work, there was authorization for PNM to attach new models of LED streetlights. So to me, that's kind of a some sort, and that's something like controlled by the industry. So is that what you had in mind here? I couldn't imagine what you were thinking about.
so to try and offer an example to answer your question, as I state on page 7 of my direct, these would be small changes relating to the exchange of billing data. So an example I could think of just off the top of my head, and excuse me, with the caveat that I'm not the IT person, it could be like a date time format of the vintages of the generation, for example, or possibly something that's come up, I think, in some of the meetings is the decimal points, or the text. Is it a text format? Is it a number format? Those sort of things. Those are some of the examples that I think that we're foreseeing here as far as small changes to be made based on the exchange of billing data information that would not be a substantive change to the tariff to require a filing and a hearing and everything else.
All right, so thank you, Mr. Babet. That's helpful. So now I'm going to go back to the sizing issue for the closing question here. And it's like, I always think I'm the dentist, when I'm doing cross-examination. This is the last question, it'll be over soon. My question is, you've already answered a few questions about the sizing. And I have to say that NMPEC is concerned about this methodology of the 6 month, the supervision or the monitoring of the bills for 6 months, and then creating a kind of red flag at the 6 month period. Mm-hmm. And so it doesn't seem to me that type of method is analogous to the one that you just described about changes in IT formats and things like that. This is a substantive change. Wouldn't you agree to what is currently existing in the statute, right?
No, I would disagree that those two are analogous to one another. One refers to a small change in a tariff based on billing data information exchange. The other is PNM's proposal for the ability to comply with the statute.
But you haven't provided anything but a conclusion, some kind of really conclusory statements about the significance of a 6 month break off, right, Mr. Babet?
How do you mean conclusory statements?
In other words, that has some significance to whether the subscription is oversized or not. That's based on your own conclusion, right? Without any data supporting it. Am I correct?
That's correct. The 6 months is currently PNM's proposal for what would be a reasonable number of oversubscription months within a year, just for further review.
and again, without any data, correct? I just want to be sure that you heard me say that.
That's correct. This is not based on a calculation. This is a proposal of half of the year.
Okay, I have no further questions. Thank you, Mr. Hearing Examiner.
Okay, thank you, Ms. Yee. Final cross-examination, staff requested 5 minutes, Mr. Black.
Thank you, Mr. Hearing Examiner. Good afternoon, Mr. Babe. How are you?
Afternoon, how are you? I'm doing well, and I still have all my teeth, Miss Yee, so thank you.
Okay. I'm going to refer to PNM Exhibit 1. Just in general, page 6, lines 7 to 8. Page 7, lines 8 to 10. Page 9, line 1. And it's basically having to do with information exchange. Do you see that?
I do.
Okay. I want to probe in this area. In the community solar program, will PNM, as a result of the program, regularly exchange information with community solar subscriber organizations?
Yes.
Okay, will PNM have access to information from its own records about participants in the program or ratepayers in the program?
Yes.
Okay. Will PNM have access to information provided by subscriber organizations? I think you've already answered that.
Yes, we will.
Okay. Would the information include a customer's consumption?
From PNM's own billing data, yes, a customer's consumption would be, we do have access to that.
From PNM's records?
From PNM's records, yes.
All right. Would the information include the generation amount attributable to that customer, which is generated by the community solar facility?
Yes, that would be information that PNM would obtain from the subscriber organization.
Oh, excellent. Thank you. Will PNM have staff who are tasked to interact with subscriber organization?
Yes.
All right. And then I want to reference the paragraph 62-16B-6A, paragraph 5, statutory paragraph. That language in the statute says a qualifying utility shall, on a monthly basis and in a standardized electronic format, provide to the subscriber organization a report indicating the total value of community solar bill credits generated by the community solar facility in the prior month, as well as the amount of the community solar bill credits applied to each subscriber. Is PNM required to follow that?
Yes, PNM is followed to require the statute, or to comply with the statute, sorry.
And it's your understanding that they will?
Yes.
All right, finally, does PNM have a method to resolve errors? I guess what is similar to the energy efficiency programs where there's a third-party administrator and there's like problems that come up. Okay, is there a similar methodology being considered by PNM to resolve errors caused by a customer or by the community solar third-party program administrator?
To be clear, I think this is somewhat different than energy efficiency, where we have the M&V at the end of the year. I think this would probably fall under a sort of dispute resolution, which to my recollection was part of the subscriber organization agreement, which was part of phase 1 of this proceeding.
Okay, so
I do believe that there's a process in place.
Okay. And would that include asking the commission to resolve the problems?
I would need to go into the subscriber organization agreement and see exactly. I can attempt to do that if you would like.
Sure, if I have got the time. If I
Okay.
don't, so be it.
Okay. Let me see.
We
here.
do have some extra time, Mr. Black, so if you want to address that.
Okay, take your time.
Okay, I will try and find it. There it is, number 12. And forgive me here, we have already established that I'm not great remembering numbers, so I'm gonna flip through this. Okay, so I think that I have found it. If we look at the Community Solar Subscriber Organization Agreement, Article 6, and that's section 6.3, data errors. It's described there. And to answer your question, I do not see the commission involved in the data errors section of that SOA.
Okay. Those are all my questions. I would like to thank you.
Thank you.
Okay, I believe that is the end of cross-examination. Mr. Rilliger, any redirect?
Yes, hearing examiner, thank you. Mr. Babe, I want to start with Mr. Black's question, but I think it'll also answer some other questions. Can you turn to your P&M Exhibit 1, which is your direct, and go to your Exhibit AJB2, page 8 of 8. Well, 7 of 8 and 8 of 8. Let's do that.
AJB2.
Mhm. It's P&M Exhibit AJB2. If I wasn't
Yes.
clear.
And attachment A.
Yes.
Attachment B, correct?
Yeah.
Yes.
And what are those documents? Can you generally describe what those are for me?
Yes, these are the proposed data exchange formats. So one is information needed by P&M from the subscriber organization. And then the latter attachment, attachment B, is information provided by P&M to the subscriber organization.
And I know, let's talk about page 8 of 8, which is the P&M to the subscriber organization data file. And I know Ms. Contreras could probably get into a little more detail if needed, but to the extent you know, is there a process for P&M to alert subscriber organizations that there is exceptions to the information they provided, such that they can correct that before the bills go out and make sure that the customer gets the correct bill credit? Is there a process for resolving data errors on a monthly basis, I guess is my question.
Yes, that's my understanding. There's a two-way communication. P&M receives the data. We have the opportunity to send back and flag any errors that we see, and that can either be corrected at that time so that the bill credits are applied correctly.
Okay, thank you. And then just going back to page 7 of 8, and this is the information that P&M receives from the subscriber organization on a monthly basis. Isn't that right?
That's correct.
Is this the first time when this field is, or when this document is, or this information, I'm sorry, this data is sent over to P&M? Is this the first time that P&M knows which customers are subscribers, what their subscription size is, or their customer community solar subscription, which is number 9? Is this the first time P&M is sort of alerted or involved in the process of knowing the customers who are subscribers and knowing what their subscription is?
Yes, the first time that P&M is aware of what customers are subscribing is when they receive this data file with the customer's information included on it.
And who, this just follows up on some questions you had from Ms. Zur and I can't remember all the attorneys who talked to you about the carryover amount, but just so we're clear that it's redirect here. Whose obligation is it to set up or sort of establish the subscription size? I mean, who's involved in that process?
The setting of the subscription size is a conversation solely between the customer or subscriber in this case and the subscriber organization.
And do you know, I think this was a question posed to another witness earlier today, do customers generally know their average annual consumption amount? Would you think they would?
I would not think they would, as I'm a big nerd for this stuff and I don't know my own usage myself.
And why is PNM concerned about potential oversubscription or something oversubscription that's inconsistent with the statute?
There's a couple of reasons I would say. One is compliance with the statute is something that PNM takes very seriously. And so this was put in the legislation, I believe, with good reason. And so compliance with that is tantamount. I think that there's a few other ones. One, if a subscription is continuously oversized, just from a practical standpoint, there could be some rollover carryover amount that never gets attributed to the customer because their usage is too low. For example, we see this currently on residential behind the meter solar that is too large, where a customer has a bank of unused energy that they will at their current consumption levels can never make use of. And then more on a policy standpoint as well, if multiple subscriptions are oversized, there's a possible that the subsidy calculation could be incorrect or very complicated to come to, because there's constantly an oversubscription being carried forward and possibly applied. So I think that's complex. I don't have an easy example that I can pull, but I think those are the three main reasons I can think of that compliance with the statute is important to PNM.
And thank you, Mr. Bobe. And do you know, was there anything established in the commission's rules to determine a check on this statutory limitation of subscription size?
No, there are currently no checks or certainly nothing is prescribed on how compliance with the statute should be gone about.
Okay. And I know you've, as a manager, as you're in your role, but not as an attorney, would you generally agree? I mean, I'm looking at, if you have the statute in front of you, so section 7, 6216B7. And I'm looking at subpart A.
I don't know that I have the statute in front of me,
Okay,
but I've read it a handful of times. So
generally, the commission is obligated to enforce the rules and the provisions of the Community Solar Act. Do you kind of remember that section of the statute?
Yes.
So it's the commission's obligation to enforce the statute, right?
That's my understanding of the statute.
And PNM has offered a proposal to aid in that process. Is that how you would characterize PNM's carryover amount proposal?
Yes, I do believe that's accurate, that our proposal is to offer an option on how compliance could be enforced.
And to the best of your knowledge, did any other parties propose, did CCSA or anybody else propose a methodology for ensuring that the subscriptions are right-sized by subscriber organizations and the subscribers?
Not to my knowledge previously, although I will give Ms. Zur credit today for offering a couple of other possible solutions.
And why did PNM think that the 6 months, well, just remind me, the proposal would not only have PNM, the proposal of carryover in 6 of the 12 months, does that trigger a report to the commission as well, so that the commission could determine if these subscriptions are right size?
Yes, the report would go to the commission of the customers that are flagging this this carryover amount in 6 out of 12 months.
And why did PNM think 6 out of the 12 months was a reasonable test for whether a subscription was right-sized?
My recollection is that it represents half of the year. And if there is a significant oversubscription for more than half of the year or at half of the year, that could trigger it. If one of the things that we think about too in energy are these the different seasons, right? So there's the shoulder months, which are the lowest usage. That's typically the fall and spring. That's about 5 months, 6 months out of the year. And then the higher usage times, summer and winter, depending on what equipment is in the home or business, again, is 6 months out of the year. And so 6 months seem to be a reasonable point to flag an account, because if we're not seeing a balance over the year in 6 out of 12 months, then there's a possible oversubscription and would be out of compliance with the statute.
Is PNM open to addressing, this oversubscription issue, or the overall policy behind making sure subscriptions are right-sized? Are you open to other proposals, or would you be open to perhaps dealing with this in a rulemaking?
Yes, PNM remains open to other proposals for compliance in the statute. And a future rulemaking after conclusion of the pilot period perhaps would be a good place to discuss it.
Okay, just a few more questions. You had some questions about CCSA Exhibit 11 from Ms. Greenwald. And one of your responses to her, I don't know that you have to refer to it because I'm just going to talk generically about one of what you discussed with her, was that the location of solar and the location of storage played an important role in the effect it had on PNM's system. Can you kind of just give us an overall why location, any location of solar or any location of storage is an important factor when we're looking at cost or avoided cost for the community solar program?
Yes, and I believe, and I don't have the reference offhand, I believe in my rebuttal testimony, I reference a study by Lawrence Berkeley National Labs where really one of the big takeaways is the most important thing when considering the cost or avoided cost or benefits of additional solar is the location. And so this is important on PNM's system as it is important everywhere else. The location of the system really does dictate what those costs or avoided costs could be. It should be clear by looking at a map of PNM's service area. PNM serves communities across the state. The service area is non-contiguous, and we do have a population center here in the center of the state and outlying service areas elsewhere that are not directly adjacent to where the population and load centers are. So location of that solar and the ability of that solar to serve a load at the location it's interconnected directly affects the costs and avoided costs.
Okay, thank you. You had a few questions from Ms. Nanasi on hosting capacity, and I know you stated you haven't run a hosting capacity analysis, but do you generally understand that hosting capacity it's done on the location or on a feeder? Sorry, let me see if I can formulate my question a little better here. The hosting capacity analysis is often done on a feeder basis. So location also is important in terms of the results of a hosting capacity analysis.
Objection. I believe that this is leading an inappropriate redirect.
I don't know if we got into that during the cross-examination. So I'm going to ask you to either rephrase your question or withdraw it. I think it is outside of the scope of what we encountered in cross-exam.
Oh, well, I know I wrote down Ms. Nanasi's question as she was going, as at least to the best of my knowledge, that she was talking about.
Objection to whatever she's saying right now. This is arguing with the hearing examiner. I believe you've made your ruling, and I'm asking her to move to the next question, please.
That's fair. I'm sorry, Mr. Mueller. I did not intend to argue with you. I was trying to clarify what I was stating. So I would like to try to rephrase my question because I think it is within the scope of Ms. Nanassi's cross, if I could.
Yeah, by all means, you can try.
Okay, thank you. You had questions from Ms. Nanassi about hosting capacity analysis. Is that correct?
That's correct.
And give me 1 second so I can phrase this right based on what I wrote down. And your understanding of hosting capacity analysis, is it done on is it based on a specific location or a specific point in the system and the grid?
My understanding of a hosting capacity analysis is that it looks at all of the feeders that are included in the scope at a snapshot in time.
Okay, thank you for that answer. Last question, and then I'm done. Does the Community Solar Act, in your view, Mr. Babet, does it intend for the utility, for PNM, to recover its lost fixed cost or its lost revenues associated with implementation of the program? Does the Community Solar Act intend that the utility is able to recover lost fixed cost and lost revenues?
Yes, my understanding of the act is that it intends for the utility to recover its costs of the program.
And what about revenues associated with those costs?
Yes, that would be included. I believe that the statute does this by looking at a possible cross-subsidization and limiting that. And certainly lost revenues could be part of that calculation.
Okay, that's all my questions. Thank you.
Okay, thank you. I believe we are complete with this witness. Witness may be excused. Let me just quickly review what we have on schedule for tomorrow as we've reached the conclusion for today's schedule of witnesses. Tomorrow morning, we'll have PNM witnesses Dwayne, Contreras, and Settlage. Buck was excused per our earlier agreement today. We'll continue with Settlage into the afternoon. And then we will have SPS's witnesses. Stephanie, the request was for Clem to go ahead of Trowbridge. Can you refresh my memory?
Yes, Your Honor. The proposed order would be for Ms. Lees to remain in her primary spot, and then Ms. Clem would follow Ms. Lees. So she would take the second spot, and Mr. Trowbridge would take the final spot.
Okay, thank you.
And while we're addressing SPS, if I may, Your Honor, we have no cross-examination for Ms. Yee's witness, Naughton. So I believe we were the only one who had listed time. So I believe he possibly could be waived if that's.
Yeah, I'm sorry. Just repeat which witness were you requesting that for?
Naughton, Ms. Yee's witness from New Mexico Peoples.
Okay. Ms. Lee, SPS is waiving the right to cross-examination for Mr. Naughton. Mr. Naughton's appearance that I had scheduled for Friday afternoon is no longer required. We will move that. Let me just open up. With that, we will move NMPEC Exhibit 1 and Exhibit 2 Mr. Naughton's testimony and the errata notice onto the record. And Mr. Naughton will not be required to appear.
Mr. Hearing Examiner?
Yes, Ms. Yee.
So I would also ask at this time for the admission of NMPEC exhibits 3, 4, 5, 6, 7, and 8. These are answers to interrogatories received by Mr. Naughton.
Any objection to those exhibits being admitted onto the record?
Hearing examiner, I'm trying to pull each of those up, but I mean, the practice would have been for Ms. Yee to get these admitted with each witness who testified. I am objecting to the admission then without actually having a witness attest to that they answered that question. It's true and accurate to the best of their view. When they see that exhibit coming up, I mean, we've been doing that with other witnesses, and we haven't just wholesale admitted responses to discovery.
Okay, tell you what, I'll give you the opportunity to review those. I know we're condensing things here. I'm not going to move them onto the record quite yet. Then I'll give you the opportunity to review them, and I will basically ask similar question tomorrow morning if you're comfortable moving down the record. Otherwise, we will have Mr. Naughton up here.
So I think these are all responses from Mr. Settlage. Is that correct, Ms. Yee?
Yes, yes, Mr. Welliger, and if it would help your review, they really go to the bill comparisons, the majority of those discovery requests and responses address bill comparisons.
And I believe Ms. Yee has time with Mr. Settlage, so I would just prefer, hearing examiner, that she ask Mr. Settlage to look at these when he's on the stand, and then we could get them admitted as part of his examination. That would be my preference.
Okay, I'm inclined to agree with you, and just noting that we will not have Mr. Naughton appear as a witness, so I will take that under advisement when she seeks to move those onto the exhibit. Okay.
Okay, thank you.
All right, Ms. Greenwald, do you have a question?
Yes, Mr. Hearing Examiner, thank you. I just wanted to point out, I think we just kind of skipped over recross for Mr. Babé. To the extent that he's still around, I would just have a brief clarification question, if that would be acceptable.
PNN, any objection? Is Mr. Babé still with us?
I don't know if he's still with us. I mean, we don't typically do that, or at least the last few hearings I've been in with hearing examiner Medeiros and others, there's not been the opportunity for recross. But I can see if he's still around. He's not turning on his camera, so he might not be in the room anymore.
Right.
If you're inclined to allow it.
I will make that determination based upon the question.
Oh, there he is.
Do you want me to go ahead and proceed?
Yes, just noting for the record, Mr. Babé was previously sworn in.
Okay, sounds good. Thank you so much. Mr. Babé, I'm very sorry to bring you back here. Just had a brief point of clarification. On redirect, Ms. Terwilliger asked you if any other parties, including CCSA, provided proposals for evaluating those subscription size and carryover amounts. Do you remember that?
Yes.
Okay, and your answer was no, not to your recollection, subject to some cross-examination questions that you received. Is that right?
That's correct. I don't recall another proposal.
Okay, Mr. Hearing Examiner, would I be able to share my screen at this point?
Which document are we referring to? I'd like to keep this as concise as possible because we are correct. Recross is typically not part of our normal functions.
Understood. I would just be pointing him to the direct testimony of Justin Barnes where he sets out a proposal for dealing with this carryover amounts.
Okay, is that available in Dropbox?
It is, yes. It's CCSA Exhibit 1.
I'm getting there. I left my binder in the other room, sorry. Okay, I can flip to a page if you would like.
Sure, yes, that works. Okay, so I am looking at page 85.
Okay.
Okay, so at line 8, Mr. Barnes stated initial reviews of subscription amounts and historic usage accompanied by the implicit disincentive for oversubscriptions and self-policing by customers, and subscriber organizations provide adequate safeguards. Do you see that?
Initial reviews. I'm reading it now.
Okay.
Okay, I do see that, yes.
Okay, great. And then I'm just scrolling up one more page to page 84.
Okay.
And starting at line 11, Mr. Barnes stated, if the commission has concerns about long-term compliance with NMSA section 62-16B-5A, a more reasonable course of action would be to direct the utilities to simply track subscription amounts versus actual usage at the individual subscriber level. The utilities could be directed to report the results of this tracking annually, but any further actions should only be considered on a minimum of 5 years of data. And then it goes on to finish the sentence. But do you see that?
Okay, yes.
Okay, and those were all of my questions. Thank you. And sorry to bring you back here again.
No worries. Thank you for directing us there.
Yeah, absolutely.
Okay, and for purposes of that recross, it's noted that Mr. Barnes' testimony contained that. However, I will limit that recross that it doesn't go to impeachment of the witness of his testimony, but merely for the fact that Mr. Barnes' testimony contained that. I feel we probably could have captured that with Mr. Barnes's testimony. So I don't really think we need to ask any more questions regarding that. But to the fact that the witness I previously not had recollection of it, I'm not going to use that recross in terms of limiting his testimony that he provided today. Let's just, for purposes, Ms. Greenwald, if you're in front of us again, next time something like that occurs, let's just do it under your witness when it's presented.
Absolutely. Yes. Thank you, Mr. Hearing Examiner. I appreciate the opportunity to provide that clarification, and in the future, we'll definitely do that.
Thank you. All right. Any other questions before we conclude for today?
Mr. Hearing Examiner,
Yes, Mr. Religer.
I don't think we've actually moved for the admission of the 2 witnesses of ours who were excused. And I thought we would, just since we had a little bit more time before 5, we would do that here. And so neither Mr. Verheul or I forget to do so. If I could move for the admission of PNM Exhibit 7 and PNM Exhibit 8, 7 being the rebuttal testimony of Cindy Buck, and PNM Exhibit 8 being the rebuttal testimony of Mr. Gutierrez.
The request is for PNM Exhibit 7 and 8, which were Cindy Buck and Shane Gutierrez. The cross-examination having previously been waived by the parties. I will go ahead and admit PNM Exhibit 7 and 8.
Thank you.
Ms. Yee.
Thank you, Mr. Hearing Examiner. So, thank you for, excusing my witness, but, as we are, as I am listening to, your, ruling on, how to handle that situation that just came up, about, how to bring in, the, evidence of, alternatives to sizing and calculating average annual consumption. I believe that Mr. Naughton or Dr. Naughton has at least foundational testimony regarding alternatives. And I would like the option of having him appear in person so that I could ask him a couple of questions about alternatives to sizing instead of what P&M is recommending.
Is that captured in his testimony, Ms. Yee, or
As I say,
are you looking to augment his testimony that will be filed?
It may be somewhat additional, but the premise, the foundation for alternatives is in his testimony.
As typically, all we're doing with your own witness is getting the file testimony onto the record, which I've already done. So to the extent that you are going to offer additional testimony would be typically not within our procedures. Let's get through tomorrow and the exhibits that you wanted to admit onto the record with Mr. Settlage. And to the extent I can keep Mr. Naughton on the schedule, however, just take that under consideration that we'd really just be putting his direct testimony onto the record without additional testimony at that time. That's our procedures.
Yes, I understand that. I think, Mr. Hearing Examiner, and thank you for explaining that. I'm just trying to reconcile that with what just happened. I suppose that what just happened is maybe a little different because Mr. Barnes did have his recommendations in his testimony. But he would have had the opportunity, it sounded like from what you were saying, Mr. Hearing Examiner, to point that out during the time that he was authenticating his testimony. And
Okay.
that's what I was trying to do.
I would just leave it at, to the extent that you feel it is necessary for him to verify that, he can appear. Parties have waived cross-examination, so if you feel you want that on the record, you can call your own witness. To the extent that he will offer, and verify that his testimony is the same as he submitted, we can do that. But, if we're going to try, I have no problem with that. So I'll leave that to you to consider. If you want to call him on Friday afternoon, but yeah, that would be the scope of the direct testimony.
Thank you, Mr. Hearing Examiner.
No problem. Anastasia, if you have a question.
Yes, Mr. Hearing Examiner, this is a very generic question about your ruling or statement a little earlier about it's not standard practice to allow recross on redirect? Because I know I've been functioning in a different EPE world from not the P&M world, but I've been under the impression that recross extends to both questions by the hearing examiner, for which you've had none, and redirect questions.
Yeah, I believe that's captured in the pre-hearing order, that that's generally limited to questions that I present or questions that, you know, if a commissioner were to come on board and ask questions, which I know we had some commissioners listening today, but not offering.
Sorry.
That's generally what's captured in my pre-hearing order. You know, however, you know, hearing examiners retain the authority to allow any additional questioning.
No, I mean, what is the basis for that? Is that just, I mean, is that an arbitrary choice? Is it a decision, a policy decision that the commission has made and not yet put in a rule? That's what I'm asking about.
I mean, I think when it comes, I don't believe NMAC contains specific rules, so that's usually contained in our order. I mean, those are usually made by the orders, either by the commission or the hearing examiner, depending on who issues it.
Okay, well then, does that, if the commission issues, if the commissioner or hearing examiner issues such an order, does that put the onus on the parties to jump up and scream and object whenever a redirect question goes ever so far beyond, you know, beyond the narrowest of the narrow? And
I would assume in my hearing rooms, basically.
Well, we don't have the opportunity.
Well, I mean, I'm just pointing out that, you know, Anthony might run it differently. Chris might run it differently. With my hearing rooms, you know, if a redirect question to you extends beyond the scope of, you know, cross-examination, then I, you know, would entertain an objection to it.
Okay.
I'm not going to make that across the board. Anthony is very set in his ways. Chris is very set in his ways. Elizabeth, for sure, is set in her ways. So I think each time when you're in front of a hearing examiner with the PRC, you know, I'm not going to prohibit you from asking. But under mine, if I feel that you feel, you know, if you feel that a redirect question is not simpatico with the cross-examination, you know, you can raise an objection for me to make a determination on.
Okay.
Otherwise, we have testimony that isn't subject to cross-examination. So, you know, for purposes of my hearing room, for purposes of my hearing room, I'm never going to yell at you for asking.
asking to recross or raising an objection.
That being said, tomorrow we are on a very tight schedule, as you all aware. We're trying to compress 8.5 hours into 8 hours. I mean, you guys did a great job of staying on time and within your time limits today, but we will be on a pretty tight schedule tomorrow. So I may not be as amenable to additional lines of questioning based upon our timelines tomorrow. But I appreciate you all today for staying within your timelines and being professional with each other. I realize we have, you know, this is a pretty large group for a hearing room. So with that, I think today is concluded, and we will start again tomorrow morning at 9 a.m. Ms. Court Reporter, did you have any clarifying questions you needed from today?
No, I don't. Thank you.
All right. Thank you, everybody. We are concluded for today.
Thank you.